issues, or basically the timeline issues, which we should say. As we all know that it has been around 7 years since IBC has been incorporated, but still the uh, the change which it wanted to have, it has not yet, it's not that visible. So what are the key factors? We all know there are a lot of kind of delays, but how we can mitigate those delays? Let us, identify some of those strategies. So before starting with the main session, I would first like you to see a case study wherein I want every one of you to be involved so that we can correctly identify what are the key issues and how you can try and mitigate all those. So let me just share my screen. Just give me a second. So is my screen visible? Just let me know.
Yes.
Yes, madam, it is visible.
Okay, okay. Thank you so much. Thank you. I'm just zooming it out a bit so that it is easy for all to, see that. So I request all of you to please remind yourselves of the days when you studied this insolvency professional course and you were, thorough with the theory, in fact, and case study portion also you might have undergone. So this is a kind of case which we are discussing, and let us have a proper brainstorming session. So how we can, resolve this case. Now, as you all are here to discuss in this particular session. So we are discussing a case of Superficial Enterprises Group. What is the background of this group? Superficial Enterprises Group, that is SEG in short, is a diversified conglomerate operating across 4 primary sectors. So it is a group of companies which is working in different sectors. So one of its companies is a steel manufacturing company. The name is SSL, that is Superficial Steel Limited. The major revenue driver, but it has recently suffered due to high operational cost and global steel price volatility. The debt for this particular company is 10,000 crores. Next, we move on to the second company, which is Logistics Service, Superficial Logistics Private Limited, that is SLL. It is critical to the group supply chain, but heavily dependent on SSL. So this particular logistics company is dependent on the first company, steel manufacturing company. Its debt is also 5,000 crores. So whosoever has joined recently, I'm just discussing a case. We are not going into the theory. We are firstly discussing a practical case. Suppose this is a scenario which you are facing. You have got an assignment where there are a group of companies and they are all into different sectors. So how you will take up that? So we will be discussing that kind of thing. The third enterprise or the third company which is into this group is a real estate development company. The name is Superficial Real Estate Limited. In short, we'll call it SREL. Stalled projects caused by a slowdown in the sector, leading to dissatisfaction among 5,000 home buyers. And the debt is 7,000 crores. And the fourth company here is of renewable energies. That is a Superficial Renewable Limited, that is SRL in short. It operates solar farms and wind energy installations with regulatory contracts, and here the debt is amounting to 3,000 crore. So overall, if we see, the debt of the company comes out to 10,000 plus 5,000, that is 15, 15 plus 7, 22 crores, then 25 crores in total. So 25,000 crores in total. And it is split into, these various sectors. So if you have got an assignment of this sort, that you have to, proceed with the CIRP of this particular company, how will you go ahead? So before going ahead, we all want to know what are the what is the exact financial structure of these companies. So the total debt, we are saying that it is 25,000 crores, out of which 20,000 crores owed to the financial creditors. Here, the assets are basically the land, bank balance, steel plants, warehouses, renewable energy infrastructure, and total estimated value of these assets is 20,000 crores. So, are you all here with me till now?
Yes, ma'am.
Can you analyze what kind of situation you can face, because there are different industries, different sectors involved here, and with each sector there are separate issues, and different kinds of financial creditors will be there in each of these things. Then in real estate, as we all know, home buyers, there are a lot of home buyers, so a lot of calculations will be involved whenever you receive the claims, and a lot of litigation can move in and out. So these are the 4 questions for you all to discuss. Let us read one by one. Question 1 is, how can the CIRP process of SEG's group companies be streamlined to address delays and inefficiencies? So I would request you all to just bear in your mind all the facts which we have already. And suppose you are given this kind of situation, how will you start the process? How will you start with the CIRP process so that there are no delays or there are no inefficiencies? We'll try for that, but since the size of the enterprise is so large and there are various segments involved, it might happen that there will be delays. But our intention is to, minimize the delays. So how will you progress so that there are no delays at all or there are no inefficiencies? That is the first question. How will you start your functioning? Second question is, what strategies can prevent asset deterioration and ensure operational continuity during the CIRP? So, as you might have all, gone any of your assignments or some of your assignments wherein you have also come across such kind of situations. So, is there any strategy which you use in those particular scenarios, and can we use those strategies here to avoid these kind of delays or inefficiencies? Okay, the third question is, how should conflicting stakeholders' interests be managed to balance financial recovery and regulatory compliance? See, we have to balance each and everything here because there are a lot of creditors involved, a lot of financial creditors involved, and everyone's stakes should be, balanced out. So, to minimize the conflicting interest, how will you strategize for this whole process, and how will you make sure that you properly comply with the regulatory requirements? That is another factor which you have to take into consideration. The next is, what innovation solutions can attract more bidders and encourage competitive resolution plans? These are the major 4 questions, because as soon as a resolution professional is involved in this kind of scenario, what is his main task is he has to maintain the value of the assets. He has to keep that intact, and he has to attract more and more bidders. He has to get more and more resolution plans, so that finally he can work out a win-win situation for each and everyone. So I would request you all, or any one of you who can answer, starting with first question. How can CIRP process for SEG group companies be streamlined to address delays and inefficiency? What will be your approach? Any one of you? Should I stop sharing the screen and let us be more interactive? Any ideas, anyone? How will you proceed for this? Okay, I think you people are not interested in answering. Then how will we proceed then? At least you can think of some of the ideas. How will you start with? You will start with which kind of companies? Anyone of you who has any background of doing this real estate cases? How do you start with these real estate cases? Or you want me to take the theory first and then we can move for this case study portion? We can do that way also. As you say, I'll proceed. I think the case is very much clear, and this is a real situation which you might also come across. The thing is how you plan it so that there are no delays, because the timeline is very stringent. Within 180 days, you have to, finalize each and everything. So how to proceed for that, that is something which we need to take care of. So I think we can answer the questions first and then we can move out to the theory part. The solutions here would be, see, these are the key challenges. CIRP challenges are, firstly, there is no group insolvency framework in India. If there is a group, how to take up that group? So independent CIRP proceeds are normally there in the Indian IBC scenario. So all these will be conflicting and they will be time taking. So it will increase the procedural inefficiency. Second is the stakeholders conflicts. That is again a kind of challenge which you will face here. Financial creditors will push for maximizing recoveries from steel and logistics. Home buyers will demand completion of real estate projects. Renewable energy regulators seek uninterrupted power supply. So all these stakeholders will be conflicting with each other. So how to manage all that? That is another challenging task for you. Next is you have to take or you have to pay more attention that assets are not deteriorated in the time span. So operational shutdowns in steel and logistics are eroding the asset value. As we all know, if the machines are not functioning, if the industry is not working, the value will sooner or later deteriorate. So how to handle that situation also? Then fourth and major challenge is the litigation and regulatory bottlenecks. So disputes over intercompany claims and environmental clearances will delay the resolution plan. So all keeping all these things in mind, how you can frame out a best solution. There's one more challenge here: limited bidder interest. So bidders are hesitant due to the complexity of interdependent businesses. As we discussed, that one company is dependent on the others for raw material or things like that. So like logistics company was dependent on the steel manufacturing company. So again, the interdependence issue will be there, and if one bidder is willing to take one of the companies, he might not be able to give a good resolution plan, because you would try to go for the group resolution plan. So nowadays in recent judgments also, there was something like you can split these things. For one segment you can ask for the resolution plan and you can go ahead. That will make the things easier rather than going for a group resolution plan. So what are the proposed solutions? For the first one, since there is no group insolvency framework, first is centralized oversight. How you can see from a centralized point of view. So firstly, you should appoint a lead resolution professional to coordinate CIRP across all group of companies. So he should have a bird eye view of everything. He should firstly monitor each and everything from the top view. He should try to create a consolidated, committee of creditors for cohesive decision making. Rather than having separate meetings, you should try and focus of forming a consolidated committee of creditors so that everyone has a say at the same time. Next, asset pooling. All the assets should be pooled so as to maximize the value. So bundle independent entities like SLL and SSL to maximize the value. Conduct joint valuation for shared resources like steel plants and logistic hub, etc. So rather than having separate valuation reports, it's better to have a joint valuation. See, these are all the suggestions. It might vary case to case, And it is just a suggestion that these are the possible solutions. It is not that this is just the recommendation, I would say. It is not that only these steps you have to mandatorily follow. These are just the recommendations which you can have just to avoid the delays. Next is you can have a unified resolution plan, allow bidders to bid for the group as a whole or strategically integrated entities, segment non-core or non-viable businesses for liquidation. So some part you can go for having resolution plan, for some you can go for liquidation strategies also if they are not working out. So that way you have to plan. You cannot take the whole thing and wait for the resolution plans to come into, because it might happen that it would delay the situation overall. So you have to identify the things or the segments which are not working, and it's better to take them into liquidation. And for the rest of the things, you can take them for the CIRP process. Then netting off the intercompany claims. So prioritizing the external creditor claims while neutralizing intercompany transactions to avoid any kind of disputes. So firstly, you should settle down the accounts before planning for the CIRP process to go ahead. So accounts should be settled first of all, so that you have the final values, what is the final liability of the company as such. So as to proceed further. For the second question, there has to be a stakeholder management strategy. Like in case of financial creditors, recovery prioritized based on asset viability, focus on steel and logistics for higher returns, adjust the recovery expectation is less viable sector like real estate. So as we know, we can have more and more value of that steel and logistics plant. So you should try and get more value from that. And then, as we know, from the real estate, we will not be having much of the value. So utilize the assets which you have, which are generating much of revenue, and you can utilize those assets for repaying the other segments. Next, the home buyers, that will surely create much of problem. So use a dedicated escrow account to fund project completion for real estate. That is the strategy which you should follow in case of home buyers. And also you should partner with alternative developers for fast tracking the housing delivery. So you should also keep it as a going concern, and you should try to get more and more out of it. Next, for the regulator purpose, maintain renewable energy operations with interim funding to ensure compliance with power supply contracts. And then for the operational creditors, propose partial cash settlements or equity participation in structured entities. So these are a few possible solutions. Then how can you keep it continue? So how this operational continuity plan can work? So firstly, you should go for the interim finance, because everything needs some or the other kind of funds to continue the process. So how this interim financing can happen? So secure a bridge financing under section 513 of the IBC to restart the steel plant and logistics operation, because that portion had shut down, those operations had shut down. So we should start with that, so that it starts generating some revenue meanwhile, and it can be sold or it can be taken up as a going concern later on. Prioritize the fund allocation to critical revenue generating assets. So this is something which you can plan. Then workforce retention. That is a major concern. What about the workforce? What about the employees? So offer performance-based incentives to retain the skilled employees, especially in steel and renewable sectors. So if you have the proper workforce and you have proper funds to manage everything, then of course, even if the entities have shut down, you can restart them. That will of course take a proper involve a proper strategy to do everything. Then supply chain stabilization. You have to partner with key suppliers and customers to maintain business continuity during the CIRP. Then how to resolve the dispute, or what should be the dispute resolution mechanism, because as we know, there will be different stakeholders and a lot of disputes and a lot of litigations will be involved. So how to handle all of that? So you should try and establish an arbitration panel. Establish a dedicated panel to resolve intercompany and operational creditor disputes efficiently. So this is something you should think ahead of. You should not wait for some disputes to come in. You should properly have an arbitration panel so that whenever any dispute arises, you have some people to manage that. Next is you should have a transparent communication. You should publish a clear roadmap for creditor recoveries to minimize each and every conflict. Then expedite the regulatory clearances. Engage proactively with environmental and sectoral regulators to secure approvals. See, all this involves regular meetings with the regulatory departments and the stakeholders, that is, and the COC. So everyone is to be, involved, and every communication should be transparent. Then only you will be able to avoid any kind of delays. Then, for optimizing the timeline, you should firstly, as we know, we all know there is a proper timeline which we have to follow. So for each and every assignment which you are given, you should have a kind of milestone or the deadline chart in front of you. So you should think ahead that for the asset valuation, we will take around 30 days. For the bidder selection, maximum it should be done in 90 days. For the COC approval, it should be finalized within 120 days. Or you can break it down further. For each and every step, you can have a proper timeline, because without having these deadlines, without having these timelines, just thinking in mind, you will not be able to do anything. You should have everything written out somewhere or the other. You should have proper charts for everything so that you do not end up with delays. Then again, nowadays you can use a lot of technologies. There are digital platforms for COC meetings, e-voting. For e-voting also, for voting also, you can opt for e-voting to eliminate procedural delays. So in order to avoid delays, these technologies for meetings and everything you can use. And nowadays, for selling out the things, or uh, uh, for your assets allocation can be done through online portal also. And then if you want to publish anything, you have to take help of the technology. Then bidder incentives. You have to offer incentives for early submission of resolution plans and penalties for plan withdrawal. So this is something which no one will tell you. This is something which should come from yourself, within yourself, that you can offer incentives also if people give you early submission of they early submit the resolution plans, and if they withdraw their plan in between, then they will be penalized. So these are a few things which you can keep in mind, and uh, then proceed with this kind of situation. See, this case study I have taken just to begin with, just to create some kind of background why we are dealing this topic today. So I'm just stopping the screen share, and then we will take up the final theory part, which we are here to discuss. What are the real life cases? What are the real examples which we can come across? So it is just that, by seeing or by studying the cases which have really happened, you can get some clue how to proceed with your assignment, whatever assignment you get. So blindly you cannot follow exactly the same which approach which they have taken, because every time the scene changes, the regulations or the law also changes time to time. So again and again you have to be abreast with the knowledge, the laws, the regulations, and the technology also. That will also help you out in most of the cases. So let us start with the PPT. I hope you all are there. Let me know if my screen is visible.
Yes, ma'am, it is
Yes.
visible.
Okay, thank you. So the topic for the day is unlocking efficiency. So that is the thing which we need to understand. We consider ourselves efficient enough, but when it comes about the cases, these kind of assignments where the things are not actually in our control, these things are totally, they sometimes become out of control, even though we want to finish up the things as soon as possible, but it is not happening the way we want to. So that is why the topic for the day we have kept is how to unlock your efficiency. looking into the out of control things also. So let us proceed. As we all know, the basis of IBC is time. So as time is of very importance here. Everything is time bound. The regulation itself has laid down various timeline for CIRP process or liquidation process. Both have different timelines for that. But we all know that the things are not completing within the time frame given, and that is the major drawback which we see, that IBC is not being able to deliver properly. It will take time, no doubt, because it has it is an evolving law. It will take time, but again, if we are given any of these kind of assignments, how we should proceed, that is something which we should be more aware of. So let us understand what is the basic objective of IBC. As we all know, it wants us to resolve these kind of cases in a time bound fashion. The next objective is to maximize the asset value. Again, it wants to promote entrepreneurship, balancing the interest of all the stakeholders. So basically, keeping everyone's interest together. We cannot, do any partiality with anyone. We have to pay regard to each and every person's interest. Then we have to maximize the asset value also. We have to take care of the time also, and then we have to, promote the entrepreneurship. We have to, take the entity as a going concern. We should try to, resolve the case rather than taking it into the liquidation. So this is what the objective of IBC. However, it is very difficult with the scenario, with the present situation. All these objectives of IBC may not be fulfilled. So these are the timelines which we all know. The regulation 40A of CIRP regulations. I mean, this clearly lays down the timeline within which you have to complete the CIRP process. It clearly mentions at the time when you should appoint the IRP. As soon as the CIRP commences, IRP should be appointed. Then when public announcement should be made, then submission of the claims, everything is laid down, but it does not proceed as such normally. But what you can do is something which we have to discuss. So these are the timelines which we all know. I won't take much of time, discussing all this. So these are the timelines for liquidation process. This is the timeline given in regulation 47. So let us discuss what is the current position.
Actually, ma'am, your PPT slide is not moving. That's fixed itself.
Is it not moving? Okay,
No,
thank you for telling me, sir. I'll stop sharing and then I'll share it again. Just a second. Thank you for telling me. Is it visible now?
Yes, it is visible now. Yes, now it is. No, yes, it is moving now.
Is it moving, sir? Is it visible?
Yes.
Okay,
moving.
okay.
It's moving now.
Okay. Thank you so much. Thank you so much. So this is the current statistics. This is the published data which we have. So we are now discussing what is the average time for approval of resolution plans or the orders of liquidation. So here you let us study how this table is prepared. First column tells you about the average time regarding particulars, basically. So from insolvency commencement date to approval of the resolution plan by the adjudicating authority, how long does it take? Then let us see the statistics simultaneously. In the first set, you can see the statistics of CIRP cases broadly during or till March 2023. So the number of processes which were covered were basically 674. Including and excluding time was around, the cases were around 611, and then excluded time, it was 507 days. So all this time is given in days. It is taking so many days. So if you see the data here, from insolvency commencement date to approval, it is taking average time. It is taking 691 days. Excluding excluded time, it is taking 691 days to clear. So that is how this will be read. From insolvency, from ICD to order of for liquidation, since we don't have the exact data, it is not mentioned here. So it is 686 days. We can take the data from here, 686 days. For liquidation scenario, from LCD, so liquidation commencement date, so we can see here 964 days it is taking. So this way, the whole table is depicting that a huge delay is taking, though the time frame is 180 days or 270 or 330 days maximum, but it is taking on an average 841 days, 691 days. I mean, it is going beyond 700 days. So 2 years, 3 years, it is taking to resolve all these cases. What is the status of CIRPs? So closure by appeal. So if any application is filed for insolvency, then whether it was closed by any appeal or review or whether it was settled. So we are discussing that. We are here on this slide. So CIRP initiated by, so who had initiated the CIRP? Suppose financial creditors have initiated the CIRPs, then the closure number is 374. So if they have closed by appeal or they have closed by review or they have settled, so there are around 374 cases which were closed by this appeal or review, or they were settled finally. Next, if they were so total, out of total cases which were filed, out of total applications which were initiated, they were closed by appeal or review or settled around, just a second. So 1,221 cases were finally closed out of the total out of the total applications filed. 1,221 cases were finally closed. Some of the applications which were initiated for CIRP, they were withdrawn under section 12A. So these were also, I mean, around 1120 cases till date. It is the data is for till date. Closure by approval of resolution plan. So around 1,068 cases are finally approved and they are closed by proper resolution plan. Out of CIRP, some cases which are converted into liquidation, these are around 2,630. And finally, ongoing cases, ongoing CIRP cases are 1,963. So as on date, till date, I would say, till date, from initiation of insolvency and bankruptcy court till date, total 8,002 applications were totally filed. And this is the settlement which we can see, that out of these total applications, ongoing cases are 1963. So CIRP yielding resolution plan. So how much resolution plans they are, how much they are yielding. So that is what we need to check here. Realization by creditors as percentage of liquidation value. So this is the data in percentage terms. We can see here how much they are realizing in terms of their value. And the last portion is CIRP is yielding liquidation value as percentage of claim. So if a person has claimed 100, then he has just got 5.5% of his claim. So this is how this will be read. And the average time taken for closure of CIRP is, 508 days, 504 days. It was like that. So this is the broad scenario, the statistics which we can see. Next is, what are the reasons for liquidation? Because sometimes we cannot why the applications which are coming into CIRP, they are moving to liquidation. So this is the broad breakdown how this is happening and for what are the major reasons for that. So around 1,859 cases were there where COC decided to liquidate this corporate debtor during CIRP. In 678 cases, adjudicating authority did not receive any resolution plan for the approval. In 63 cases, adjudicating authority rejected the resolution plan for non-compliance with the requirements. In 30 cases, corporate debtor contravened the provisions of resolution plan. So these are the major reasons why any corporate debtor goes into liquidation. Details of CIRP cases as on September 30th September 2024. So total cases which were admitted till date, they are 8,002, out of which withdrawn cases are 1,120. These have been withdrawn under section 12A. Out of these CIRP cases, further, they have closed on appeal or review or they are settled. 1,222 cases have settled already. Resolution plans approved. So total 1,068 resolution plans have been approved so far. For how many cases liquidation orders have been passed? For 2,630, finally, the liquidation orders have been passed. And ongoing CIRP cases are 1,963, that is 1,963. So this is the statistics as on date, which we have. So finally, how many applications were admitted, how many are closed, and how many are ongoing. This is the data which we have in totality. If we see the timeline, how long does it take to, finally complete the CIRP process and all? So we can see here that there are very few cases which are, completing within 90 days. So there are just 8% cases which are completing in less than or equal to 90 days. Then 11% of the cases are there which are in the time frame of 90 to 180 days. So the CIRP process completes within that time. Either the application is, withdrawn or something like that. So it settles down that way. Then in ongoing cases, we are discussing this timeline in the ongoing IRPs, what is happening. So in the current CIRP, there are cases which are 270 days old also, more than 270 days old. So around 71% of the cases of the current CIRP cases, which we have just read that it is around 1,900 cases or so, more than 71% cases are more than 200 days, 270 days. They have already taken a span of 270 days. So you can very well imagine the situation that more than 70% of the cases which are there in CIRP, they do not end up into the fixed time frame. They more or less take more than, in fact, I would say 270 days to complete. What can be the reasons for delay? As we all know, some of the other, we will be blaming the NCLT for that. So delays in the NCLT proceedings, despite the prescribed timelines, delays in NCLT's admission and approval process can prolong the CIRP proceedings. So though we file the application, but it takes a lot of time to get admitted. And then again, once it is admitted, a lot of problems, a lot of litigations are there. Then again and again, it consumes a lot of time. Then sometimes there are complexity of claims also. So verifying and reconciling large volumes of claims, especially in cases involving numerous operational creditors or home buyers, can be challenging. So if there is a small assignment, then it might not be amounting to very complex situations regarding the verification of claims and all. But in case of real estate projects or bigger projects, in that case it is very difficult to verify and reconcile the large volumes of the claims. So that is a major challenge there. Again, there is a dispute regarding the valuation. So there are disagreements over the valuation of the corporate debtors assets. and this can complicate the approval of the resolution plan. Recently, there was some guideline by the IBBI also, that how this valuation methodology should be used. So prior method of valuation should be discussed with the method of valuation should be prior discussed with the COC, so that later on there are no disagreements or lesser disagreements. So again, valuation plays a very, very important role, and this also creates various kind of disputes. Then what are the various practical challenges besides all these challenges which we have seen, these various reasons of delays which we have seen? What are the various practical challenges which we can face? So first is the legal and regulatory challenges. In many of the cases, we see that there are multiple litigations going on. So RPs often deal with numerous litigations from creditors, debtors, and other stakeholders, which can delay the process. Though he wants to, sort it everything in a very short span of time, but these litigations delay the process. For example, in the case of SR Steel case, multiple appeals and litigations delayed the whole resolution process significantly. Next challenge in the regulatory framework itself is the regulatory compliance. Ensuring compliance with various regulatory requirements, including those set by the Insolvency and Bankruptcy Board of India, SEBI, and other sector-specific regulators, can be time-consuming. Since you want to keep the corporate data as a going concern, it requires you to fulfill various regulatory compliances. So to fulfill each and every requirement, takes a lot of time, and you have to take care of all the compliances. And even if you fail any of the compliance, then again there can be serious issues for that. Then NCLT delays. This we have already discussed, that despite the IBC's prescribed timelines, delays in NCLT's adjudication due to a backlog of cases can hinder timely progress. For example, delays in NCLT decisions were a significant issue in the Bhushan Power and Steel case. Next is the operational challenges. So while performing the task also, you might come across various challenges. So complexity of business operations, sometimes because we don't understand how this will operate, because each and every sector works differently. So there are situations where the issue becomes very complex. So understanding and managing the day-to-day operations of the corporate debtor, especially in large and complex business, can be daunting for the RP, because he is not very, thorough with the business acumen. So he has to take help, professional help. It is always advisable that he should take some or the other professional help wherever he wants. The example is also there. The resolution professional in case of JP Infratech had to manage complex real estate operations and deal with numerous home buyers. Then next operational challenge could be asset valuation. Accurate valuation of the debtor's assets is crucial for formulating a feasible resolution plan, but can be challenging due to market fluctuation and the unique nature of the assets. This we all know, this we all understand also. The timely valuation will, give a better result. But if it is, if the CIRP process is going on for a long time, then again it will decline the value of the assets. And again, you will have to ask for the new valuation reports. Then verification of the claims. Verifying claims from a large number of creditors, especially in cases involving numerous operational creditors, can be a meticulous and time-consuming process. In the case of Reliance Communication, the RP had to verify claims from thousands of operational and financial creditors. So I think you can very well imagine the task which RP has for verifying, thousands of the claims. And within the time frame, you have to do everything. So it becomes a very difficult task sometimes. Next challenge could be financial challenge. So how to manage the working capital, that if you want to, keep the corporate data as a going concern, then again, you have to have a proper working capital. So ensuring adequate working capital to keep the corporate data as a going concern during the CIRP can be challenging. Example, the RP in the case of Alok Industries faced difficulties in managing working capital needs to continue the operations. Again, there could be a challenge related to cost management. Managing the cost associated with the CIRP, including the legal fees, professional fees, and the operational expenses within the budget can be demanding. Then funding resolution plans. Securing financing for resolution plans, especially in distressed sectors, can be significant hurdle. So, as we discussed earlier, also you should have a proper interim finance. If you should plan for a proper interim finance if you want to, don't want this kind of challenges, financial challenges with you. Next challenge could be stakeholder management challenge. Coordination with the COC. RPs must work closely with the committee of creditors to ensure that their decision aligns with the creditor's interest, which can be challenging given the diverse interest of different creditors. Though it becomes a very tedious task sometimes because it is not always that you can keep everyone happy. So again, it is suggested that you must, work closely with the committee of creditors. You should have regular meetings with them. You should be very transparent with them so that you can understand what they want and you can easily get the confirmations from them. Then managing expectations. Balancing the expectations of various stakeholders, including creditors, employees, suppliers, and shareholders, can be complex. We all can very well understand, to keep everyone happy is not that simple. And there are so many stakeholders in CIRP proceedings. So, in order to make one happy, the other will no doubt be frustrated or something. So, it's always suggested that keep a balance, try to keep a balance as much as fruitful things you can do for each of them. Then you should try to balance the interest of each and every stakeholder. Then proper communication. Communication is the key, finally. Maintaining clear and transparent communication with all the stakeholders throughout the CIRP is essential, but can be logistically very, very challenging. But again, you can take help of the technology and you can, keep them updated. You can circulate whatever details you have prepared or whatever you want the approvals of. You can, timely communicate and get the proper solutions for that. Next is the strategic challenges. Formulating a viable resolution plan. So again, this is a very, very challenging thing because this is not at all in your control. Identifying and formulating a viable resolution plan that satisfies the COC and is feasible for the corporate debtors revival can be very, very challenging. For example, in the case of Amtech Auto, multiple resolution plans were rejected before a viable plan was accepted. And since you can very well understand here, if multiple resolution plans were rejected, it will take a lot of time. So that is how the CIRP proceedings are taking a lot of time. Negotiations with the bidders. RPs often need to negotiate with multiple resolution applicants to maximize the value for the creditors while ensuring the feasibility of the plan. So again, negotiations have to be done with the bidders. It is the task of the RPs before taking up the things with COC. So this is something which you should take care of. Then next is the market conditions. Adverse market conditions can impact the interest of potential resolution applicants and the overall success of the CIRP. So these are some things, these are the external factors which are not in our control. But if you can think ahead of time and you can plan things in advance, you can obviously meet out these challenges or mitigate these challenges. Then there could be challenges with respect to documentation and reporting also. So maintaining proper records, keeping comprehensive and accurate records of all activities, decisions, and communication during the CIRP is essential, but can be very burdensome. We all know that documentation takes a lot of time, and time to time we have to report to various monitoring institutions also. So, how to keep a proper track of it? You should always try and use the technology for that. So, proper things will be done only if if you take the help of proper tools. AI tools are nowadays available to help you out with all this. Regular reporting. RPs are required to submit regular reports to NCLT, COC, and other regulatory bodies, which requires meticulous documentation and timely submission. So if you forget any of the deadlines, then again penalty action will be there. So of course, everything has to be taken care by the RP. But we all understand that this is no doubt a tedious task, but if we are given this responsibility, we have to do it. So we can all do that in a very, very efficient manner. Just the thing is, we should plan something in advance, but ultimately the result is not in our hands. But it is just that we should try and prepare ourselves for the whole task. That is the thing. So if any delay is there, what do you think? What will be the impact of that delay? So is it always negative, or there could be some positive impact also? What is your view on that? I'll request you to please speak out a few impact of delay, whether it is positive or negative. What do you think? Well, what will be the impact? Though we have discussed a few things, but still, what is the impact of delay?
Delay on which part? Delay on whose part? Maximum cases NCLT is delaying the process. Then who will be responsible for that delay?
The responsibility, you also understand that it is not that RP is not doing the things in proper time, because we are just saying that it is not in our hands totally.
But blame at the end of the day, blame will come on the RP.
Yes, sir. The real situation is that, because, but still, we have done everything, in a good fashion or in a systematic way. But if you have proper documentation, you can always, show that you have done the things in time, and the things, if they have not turned into good or a time-bound manner, it is not your fault. Ultimately, you can show the evidences you have if you have the proper documentation.
In many cases, what happened, delay is on part of the NCLT. They were sitting on the application. Then bench changed and new judge came and he ordered कि RP has not filed application against the delay of the NCLT. Without any order, how can an IP can file the application against any order?
Exactly, sir. Exactly. But again, this is always rebuttable, sir. You can always reply in that case.
Nothing there.
So these are the practical challenges. You and I also
That's why it is very rosy in the theory, but it is very thorny in practical.
Perfectly agreed, sir. Perfectly agreed. Because there are things where regulatory requirements have to be changed. So we need to have a proper setup for the insolvency cases handling. So a proper dedicated NCLT should be there for that. But again, all these suggestions are there with the IBBI. But I don't know by what time they will, implement each and everything. We are not in a proper framework stage as of now. So again, since this is an evolving thing, and we all have taken this as a profession, so everything has a good side and a bad side also. So we have to be with it, sir. So let us come back to the thing. What is the impact of delay? So ultimately, see, whosoever is responsible for the delay, but ultimately the thing is the value of the assets are deteriorating. You won't be able to have the same valuation as it was there on day one. So it will surely affect the value of the assets, but sometimes it can have a positive impact also. So we are here to discuss both negative and positive impacts of the delay. So what are the negative outcomes? First is the erosion of the asset value. So prolonged insolvency proceedings can lead to asset value deterioration, loss of customer interest, and disruption of business operations. Increased cost. Longer timelines often mean higher administrative and legal cost, which can further strain the financial resources of the corporate debtor. Stakeholder fatigue. Protracted processes can lead to stakeholder fatigue, decreasing the willingness of the creditors and investors to engage constructively in the resolution process. So ultimately, everyone will become, frustrated if delay is happening. Then judicial overload. Extended timelines can contribute to the backlog of cases in tribunals, affecting the overall efficiency of the insolvency resolution system. Then there could be some positive outcomes also. First is we can have better resolution plans. If you have proper time, then if you have proper time, then you can have proper resolution plans also. Sometimes it happens that in hurry we don't in order to finish off the case in time, we might not have the resolution plans from very interested, or the correct resolution plan, or the maximum value showcasing the final from the resolution applicant. So ultimately, if you are given sufficient time, whether it is due to delay or whatever, sometimes it happens that you may receive better resolution plan. So improved quality of bids. Additional time may allow for more thorough preparation and submission of resolution plan, potentially leading to better offers and more sustainable business revival strategies. For example, in complex cases like that of SR Steel, extended timelines allowed for more competitive bidding, which ultimately maximized creditor recovery. Then detailed due diligence. Extended timelines can enable prospective resolution applicants to conduct comprehensive due diligence, leading to more realistic and executable resolution plans. Then stakeholder negotiations. More time can facilitate negotiations between stakeholders, leading to mutually agreeable solutions that may not have been possible under strict deadlines. It might also result in maximizing the asset value. So avoiding distressed sales. Forced adherence to strict timelines might result in undervalued asset sales. Additional time can prevent fire sales and ensure assets are sold or restructured at their true market value. Asset stabilization. Extra time might be required to stabilize operations and preserve the value of the corporate debtors' asset, particularly in industries with longer operational cycles. Then the third positive outcome could be addressing complexities in larger cases. Handling complexities, that is large and complex insolvency cases such as those involving multinational operations or significant liabilities, may inherently require more time for effective solutions. Because as you can also understand, each and every case cannot be judged on the same parameter of that 180 days, because every case is a different thing. So if there is a large complex case, then obviously you need to have more time. But IBC's has set a same parameter for each and every case. So again, if there is a complex issue, timelines could be different for those issues. That has to be there in the regulatory framework itself. But again, this is again not there as of now. But if you try to put in longer time, but again various parameters have to be there to judge on what the criteria you have decided that this particular company or this particular entity will require more time. So again, it is only by the way of prolonging this CIRP cases, only then you can have a proper timeline to fix the complexity of these situations. For example, in the case of CIRP of JP Infratech Limited, which faced numerous delays due to its scale and complexity, involving multiple home buyers, financial creditors, and operational issues. It was not that easy to handle everything in the span of 180 days only. So there are circumstances which require you to go for the delays. Then strategic planning. More time allows for detailed strategic planning and execution of turnaround plans, which can be crucial for reviving distressed businesses. So proper strategic planning can be done if if you have sufficient time. If you don't have much time, then again things become very difficult. But it does not mean that you should delay your projects or things like that. But if if delay is there somehow, it can be taken on a positive side or a positive note also. So now let us discuss a few cases where the delay has been there and it has impacted the value of the assets and how it was finally sorted out. The first case is the SR Steel India Limited versus Satish Kumar Gupta. I think you all are aware of this case. The background is SR Steel was one of the largest CIRP cases under the IBC involving a significant number of creditors and complex inter-creditor disputes. Its insolvency process began in 2017 after the company defaulted on substantial debt. This high-profile case involving over 54,000 crore in debt attracted bids from top global domestic players, including ArcelorMittal and Numetal. The CIRP of SR Steel took over 700 days, far exceeding the 330-day statutory deadline set by the IBC. The process was delayed by multiple rounds of litigation at various levels, including the NCLT, NCLT, and the Supreme Court, with the primary dispute centered on the distribution of recovery amounts between the operational and financial creditors. So this was the major issue here. The line of dispute was how to distribute the amounts between the operational and financial creditors. What was the basic reason for delay? Litigation over the eligibility of the bidders. ArcelorMittal and Numetal were initially disqualified under Section 29A of the IBC, leading to protracted litigation over their eligibility. Multiple appeals were filed with NCLT, NCLAT, and Supreme Court to sort out these issues. So, as we all understand that these litigation are obviously a reason for delay. So this has happened in this particular case also because of this particular Section 29A disqualification. It has happened in this particular scenario. Disputes over this role of COC. So what was the dispute over the role of COC here? Conflicts emerged over the distribution of resolution proceeds between financial and operational creditors, leading to prolonged debates and judicial interventions. Then there was challenges by operational creditors. Operational creditors argued for a more equitable distribution of resolution funds, which required judicial clarification from the Supreme Court. Next reason for delay was multiple appeals and jurisdictional overlap. Stakeholders filed appeal to NCLT, NCLAT, and eventually the Supreme Court, each round adding significant time to process. So a lot of litigations were there, and therefore it was hampering the overall time period of the case. This is the fact sheet. The outstanding debt of SR Steel was 49,000 crore. Recovery achieved was 42,000 crore by ArcelorMittal after 800 days. So even if it has taken a long time, still good recovery was there. You can see here. Estimated loss due to delay. Operational shutdowns led to additional financial stress, estimated at 2,500 to 3,000 crores in unrealized operational revenue. Litigation cost, including legal fees and asset valuation disputes, added an estimated 100 crores. Obviously, the fees, legal fees would go higher and higher if a lot of litigations will be there. Then asset deterioration due to delay impacted recovery value by 5 to 10%. Though it was not much of decline, I would say, but still there was asset deterioration by 5 to 10%. Then what was the final judgment? The Supreme Court ultimately upheld the primacy of the COC commercial wisdom, their decision-making ability, and ArcelorMittal's bid was finally approved, but it only happened after 2 years of delay. The Supreme Court upheld the primacy of COC in making commercial decisions regarding resolution plan, reinforcing the objective of the IBC to ensure the time-bound resolution. So what could be the outcome or the efficiency insights from this particular case? First is the COC's role should be streamlined. The ruling emphasized that the commercial wisdom of the COC is paramount and not open to judicial interference, which is a significant step towards reducing delay. Second insight which we can have from this case is the valuation adjustments. The judgment also highlighted the necessity of fair valuation practices, balancing the interest of financial and operational creditors. Let's move on to the next case. The next case is regarding JP Infratech Limited. The background of the case is like the CIRP in JP Infratech spanned more than 900 days, largely due to the complexity of the case involving a large number of home buyers as creditors. It faced insolvency after failing to deliver residential projects impacting over 20,000 home buyers and multiple financial creditors, leading to a unique challenge in managing this large and diverse creditor class. This case illustrated the complexity of including home buyers in the creditor class. The COC had to be reconstituted multiple times, leading to procedural lapses and an extended resolution process. What was the final outcome? Eventually, NBCC's bid was approved after several rounds of litigation, but delays diminished asset value and increased the cost. What were the reasons for the delay? First is the inclusion of home buyers as financial creditors. The Supreme Court's landmark judgment, that is Chitra Sharma versus Union of India, as it was mentioned that to include home buyers as financial creditors created new procedural requirement as the insolvency process had to accommodate over 20,000 home buyers, requiring significant adjustments to the COC's composition and the voting procedures also. Complex creditor coordination. Managing communication and voting process for such a large creditor class was cumbersome, as most home buyers were new to the insolvency process. A delay of over 2 years ensued as multiple rounds of bidding were required due to conflicting interest of home buyers, financial institutions, and other creditors. Frequent changes in resolution plans. Repeated changes to the resolution plan to accommodate home buyer interest resulted in delayed approvals and judicial interventions. Then there were multiple stakeholders' interest also involved here. Competing interests between institutional creditors, home buyers, and other stakeholders led to the repeated delays as new claims and appeals were filed regularly. So this is the overall fact sheet. Let us see this. Outstanding debt was 22,600 crores. The delay was over 1,700 days in CIRP. Estimated loss due to delay. Home buyers, that is around 20,000 individuals, faced prolonged delays in delivery, resulting in personal financial loss, that is rent or EMIs, exceeding rupees 500 crores cumulatively. For creditors, delay in asset liquidation reduced expected recovery by 2,000 to 3,000 crore due to depreciation in project values. Legal and administrative cost during extended CIRP exceeded rupees 50 crores. So final judgment, which is based on the Chitra Sharma versus Union of India Supreme Court decision. The Supreme Court ruled in favor of prioritizing the interest of the home buyers, effectively categorizing them as financial creditors. So what could be the learning outcome of this particular case? First is the class of creditors management. This case set a precedent for managing claims from a large number of home buyers, necessitating a formation of a representative committee to streamline the process. So even whenever you come across such situation where there are a large number of home buyers, nowadays it is very much obvious that we should have a representative committee for that. Judicial intervention. Judicial support for the home buyers helped improve trust in the IBC, ensuring that individuals impacted by corporate defaults are not left unprotected. So this case particularly, it makes us all to understand it is saying that it is a need of the hour to have a dedicated guideline for real estate insolvencies. Cases involving real estate companies require separate guidelines to address delays related to large diverse creditor classes, because the law is not very much clear in each and every thing for these particular cases of real estate. So again, sooner or later we will have these kind of guidelines by IBB that we will have to follow in particular cases of real estate so that delays can be avoided. Next case is Videocon Group. Videocon Group's CIRP extended far beyond the prescribed time limit due to the complexity of coordinating insolvency across multiple subsidiaries. It involved 13 companies under the group umbrella, highlighted challenges in managing insolvency for conglomerates. Total debt of the group was over 61,000 crores. What were the reasons for delay? First, absence of group insolvency framework. We all know that there is no group insolvency framework as of now. The IBC does not yet have a framework for the group insolvency, which led to separate CIRP processes for each Videocon subsidiary, causing inconsistencies and delays. It complicated coordination and valuation across Videocon's 13 subsidiaries. Then again, there were valuation disputes which caused delay, with numerous entities under the Videocon group valuing assets accurately. There were different opinions with respect to the valuation methodologies used. They were challenging, then leading to disagreements among the creditors and further prolonging the resolutions. Then another reason for delay was lack of consolidated proceedings. Since there was no consolidated proceeding mechanism, each subsidiary underwent a separate CIRP, adding delays and making the asset realization difficult. Legal and procedural complexity. The group's complex corporate structure involved multiple stakeholders, each filing appeals and challenging the resolution plan. So this was same like the case which we studied as we started the session. It was the Videocon group also had multiple variety of companies, different subsidiaries, and thereby since there was no proper group insolvency mechanism, so it caused delay in the overall thing. What is the fact sheet of this? Outstanding debt, it was this much amount of final outstanding debt was 64,000 crore or something, or 69,000. In fact, in first sheet it was 69,000, so that will be the thing. Recovery achieved was just 2,900 crore, that is 4.5% after over 450 days. Estimated loss due to delay, significant depreciation in the value of the core assets of the company, resulting in an estimated loss of 5,000 to 7,000 crores for the creditors. Extended CIRP increased administrative costs by 100 to 150 crores. Then delayed resolution discouraged potential resolution applicants, further reducing competitive recovery offers. What was the final outcome? The CIRP extended beyond 3 years. IOC ultimately accepted a combined bid from Twin Star Technologies, but asset value had diminished significantly by the time the resolution was completed, reducing the recovery dates. So what can be the learning outcome from this particular case? So first is there should be a mechanism of this group insolvency framework. So adoption of group insolvency framework should be there. Implementing group insolvency provisions can streamline the proceedings for conglomerates and enhance the asset realization. See, these seminars and all these are here for us to discuss what are the basic problems which we are facing or the basic difficulties which we are facing, and then suggestions are also given through this platform that we are now in a situation that we should be focusing more and more on this group insolvency frameworks or any other regulation requirement which can minimize the overall time frame or minimize the delays. Then standardizing the valuation methods. This is also the need of the hour. We need to standardize the valuation methods. Ensuring uniform valuation standards across entities can reduce disagreements and prevent the delays. Next case is regarding Lanco Infratech Limited. I hope you all are with me because we have around 10 cases to discuss. If you want, we can discuss them all.
Yes, madam, we can discuss all.
Okay, thank you, sir. Thank you. So Lanco Infratech Limited, the background was like it is a large infrastructure. It was a large infrastructure firm with a debt of over 45,000 crores entered CIRP after defaults on several large infrastructure projects. It entered liquidation after several failed attempts to attract a viable resolution plan, making it a notable example of swift liquidation following an unsuccessful CIRP. Despite initial attempts to resolve through CIRP, it ultimately proceeded to liquidation after an extended process lasting over 500 days. So after lot of attempts to finalizing this CIRP, it could not happen that way. So ultimately, it had to liquidate. What were the reasons for delay? First was the failure to attract viable resolution plans. Multiple bids for Lanco Infratech's assets were found unsatisfactory, which led to further rounds of bidding. Then repeated judicial appeals. Various creditors and stakeholders, unsatisfied with the COC's decisions, filed appeals, each of which required judicial intervention and extended timeline. Complexities in asset valuation. Disagreements over the asset valuation between COC and bidders added further time to the process. Let us discuss the fact sheet. The outstanding debt was around 44,000 crores. The liquidation value was less than 5,000 crores. Delay. It was over 1,000 days in CIRP. Estimated loss due to delay. Operational inactivity resulted in revenue losses exceeding 10,000 crores. Asset degradation including stalled projects, reduced realizable value by at least 7,000 crores. Additional legal costs due to repeated litigation were estimated at 50 to 75 crores. Finally, referring to the Ruchi Soya Industries versus Union of India case, the court affirmed the need to close non-viable CIRP quickly, reinforcing that liquidation should not be seen as a last resort, but as a practical outcome when resolution is not feasible. So what can be the learning outcomes for us with respect to efficiency? First is you should streamline the liquidation. The case underscored the importance of identifying non-viable cases early to avoid extended CIRP timelines that erode the asset value. Judicial support. Courts upheld a pragmatic approach to liquidation, reducing delays and ensuring faster realization for the creditors. See, all these are kind of suggestions to the regulators that cases which cannot be resolved in CIRP mechanism should be clearly taken to liquidation. So that should be that is a kind of recommendation through these particular cases. So we should have, this is the need of the hour. There has to be a clear pathway to liquidation, developing faster mechanism for liquidation in cases where CIRP is not viable, and this could enhance recovery rates. Valuation protocol should be there. Establishing clear asset valuation protocols at the onset of CIRP could reduce bidder hesitancy and expedite the process. This is the need of the hour, which we should always recommend to the regulators, that we should have this kind of framework with us. Before going to the next case, we can have a break of 5 minutes. We can have a break of 5-10 minutes. We will assemble after that.
Yeah, yes.
Okay. Okay. Thank you. Let's resume the session.
Yes, ma'am, we can start now.
Yeah, okay. So I'll just share the screen then. Is it visible?
Yeah, it's visible.
Okay. So the next case we are seeing is of Diwan Housing Finance Corporation Limited, that is DHFL. We should first understand the background of this particular CD. DHFL was one of the first financial services company. As you all are aware that because of this, new regulations were introduced. Altogether, a different sector of creators were there. Different set of a new regulation, a new framework was introduced with respect to this financial services companies. DHFL was one of the first financial services companies to enter insolvency under IBC after a series of defaults and financial irregularities. Default on debt exceeding 90,000 crores. This case illustrated the IBC's inability, in fact, ultimately it went like that, to manage large, complex financial institutions. DHFL's CIRP exceeded the statutory period primarily due to its status as the first financial services company in IBC proceedings, which involved new regulatory considerations. So soon after this case, new framework was introduced for them. So this was first of its kind financial institution case. The lack of precedent, this was the reason of delay because this was one of its own kind. This was totally new thing. So as we know, the IBC is evolving, and till that time when this case, the application for this case came up, there was no legal framework how to handle this kind of a situation. So since this was first of its kind, the lack of precedent in handling financial services companies under IBC introduced regulatory and procedural uncertainties requiring additional oversight from the regulatory bodies such as RBI. Then there was a Swiss challenge process here. The use of a Swiss challenge bidding process to maximize recovery was complex and time consuming as it involved additional rounds of bidding and bid matching. So this Swiss challenge word you have come across, I think in PPIRP cases, wherein the bidder's bid is matched with the base bid. Then again, he is given a chance whether he has to, revise his bidding or whatever thing. So they can, keep on revising their bids. So that way it is taking more and more time. Then there was a lot of public interest considerations. Given the scale of DHFL's default, the public interest was heavily scrutinized with multiple public sector entities and private investors filing claims, leading to additional procedural steps and approvals. So since this was a financial institution, a lot of public interest was involved. So again, there was at that point of time there was no framework to address all those situations, and till date in fact we need to revise our framework or add some more points to the existing situations. What is the fact sheet? The final outstanding debt was 83,000 crores about. Recovery it has achieved, that was 45% of it, that is 37,250 crores, and that too after 450 plus days. Estimated loss due to delay, loss of value in the loan book due to non-performing assets growing during the extended timeline was estimated 8,000 to 10,000 crores. Increased legal and regulatory cost due to disputes exceeded 150 crores. Delayed resolution reduced confidence in financial sector recoveries, discouraging future bidders. What was the final outcome? After more than 450 days, the resolution was completed with Piramal Group acquiring DHFL's asset through a successful bid. The prolonged timeline, however, led to reduced asset value and diminished creditor recovery. The learning outcomes from this particular case was that innovative liquidation strategies the Swiss challenge were involved here. DHFL's case involved a Swiss challenge auto auction mechanism to maximize the asset value, setting a precedent for transparent bidding practices. Managing public interest. As a non-banking financial company, NBFC, DHFL's insolvency also required balancing public interest with private recovery, emphasizing the importance of structured asset sales. So again, the recommendation which is given from this particular case is for establishing the financial services insolvency framework and encouraging the bid transparency process. Next case is Bhushan Steel Limited. See, these all are very celebrated cases or very important cases which you have read whenever you were preparing for this insolvency professional examination. But again, with respect to the topic given today, that delay in these kind of CIRP proceedings or liquidation, that it hampers the overall asset value. So that is what we are studying from these situations, and ultimately we have to understand where could they improve, or if there was no mechanism at that time, then if it has some new framework as on the current date, then we have to adapt to that situation and then we have to work accordingly. See, it might happen that since this is an evolving law altogether, and the current situation might also differ. So again and again, till date, whatever the laws are there, they might not be sufficient enough to cater to the needs of the current economy structure or the current industry scenario or the current cases which we might be having. So it is a regulatory requirement that they need to change. But again, being a professional, how we should deal with the situation, this should be in our hands, and we should think ahead of those situations and plan accordingly, so that on our part we are not blamed for the delay. What is the background of this Bhushan Steel Limited? Bhushan Steel, one of the largest steel makers in India, owed over 44,000 crores to lenders and entered CIRP in 2017. Tata Steel emerged as a successful bidder, acquiring Bhushan Steel for around 35,200 crores. What were the reasons for delay? Competing bids and litigation. Competing bidders, including JSW Steels, filed multiple appeals challenging the COC's decision to favor Tata Steel's bid, leading to prolonged litigation. Then there were regulatory approvals. Given the scale of transaction, regulatory bodies required additional scrutiny and approvals, adding delays to the resolution timeline. Then there were valuation disputes also. Disagreements arose regarding the valuation of Bhushan Steel's assets, further complicating the CIRP and delaying the COC approval. Let us discuss the fact sheet. The outstanding debt of Bhushan Steel was finally 44,000 crores, and the recovery achieved was 35,200 crores, that is around 80%, which is good enough. However, if delay was not there, then this could have been more. So approximately delay was of 270 days. Then estimated loss due to delay. Operational inefficiency during CIRP resulted in an estimated revenue loss of 1,000 crores. Legal costs and prolonged valuation disputes added 50 to 75 crores to the resolution expenses. What was the final outcome? Despite complexities, Bhushan Steel CIRP was completed in about 270 days, an achievement given the scale and competing interests involved. So this was really a fantastic case wherein, despite of all the complexities, they could finally achieve their target within 270 days itself. The acquisition by Tata Steel marked one of the largest recoveries for the lenders under IBC. What are the efficiency insights which can be seen from this particular case? It encourages faster dispute resolution for competing bids. Clear protocols on handling competing bids could reduce delays caused by the appeals and litigations. Then streamline regulatory approvals. Obviously, this is the recommendation which we can have. Fast tracking regulatory clearances for large scale deals could expedite the resolution process for major companies. Next case is regarding Alok Steel Industries Limited. The background of this particular case is like Alok Industries was a major textile manufacturer owned owed creditors over 29,000 crores and entered CIRP in 2017. The resolution process saw Reliance Industries and JM Financial ARC jointly submitting a bid. What were the reasons for delay? There were disputes over the haircuts. The significant haircut proposed by Reliance Industries and JM Financial, which was over 80% haircut which they had suggested, sparked objection among the certain creditors who contested the valuation and recovering percentages. Judicial intervention on the valuation. The NCLT and NCLAT reviewed appeals related to the proposed haircut, delaying the COC's ability to finalize the resolution plan. Extended negotiations. Given the opposition to the haircut, the COC faced extended negotiation to arrive at the consensus, delaying the timeline further. Let us discuss the fact sheet. Outstanding debt, as we know, was 29,000 crores. Finally, they achieved a recovery of just 17%, which was also after a delay of 650 days. So estimated loss due to the delay was regarding the value erosion in the textile assets due to the market changes was estimated at 2,000 crores. Prolonged disputes over haircuts reduced overall recovery prospects by 5 to 7%. Legal and procedural costs during the extended CIRP exceeded 50 crores. So, I mean, this is just the procedural cost will be there. Obviously, the legal complications, if they are there, then again, it would add to the overall CIRP cost. Then what was the final outcome? The resolution was eventually approved after 650 days with Reliance Industries and JM Financial acquiring the company for around 5,000 crores, significantly below the outstanding debt. So what can be the learning outcomes from this particular case? First is we should decide the limits on the haircuts. Establishing guidelines on or thresholds for accepting haircuts could streamline the approval process and prevent prolonged objections from the creditors. Second could be streamlining the stakeholders' approvals. Fast-tracking the appeal process when valuation disputes are raised could reduce delays in finalizing the resolution plans. Next case is regarding Bhushan Power and Steel Limited. The background is that Bhushan Power and Steel Limited, owing over 48,000 crore, entered insolvency proceedings in 2017. JSW Steel was selected as the successful bidder with an offer of 19,700 crores only after a prolonged bidding war. So what were the reasons for delay here? Competing bids and multiple appeals. A highly competitive bidding process led to litigation by rival bidders challenging JSW's steel offer, requiring judicial intervention at multiple levels. Then there were regulatory hurdles also. Due to allegations of financial irregularities and fraud against Bhushan Power's former management, regulatory agencies became involved, delaying final approvals. Then there was one more reason of delay, which was again this valuation dispute and extended negotiations, differences in asset valuation and concerns over recoverable value extended the COC's decision-making timeline. Let us understand the fact sheet here. The outstanding debt was 48,000 crore as we have just read, and the recovery achieved was just 41%, and that too after a delay of 850 days. More than in fact that. What was the final or the estimated loss due to the delay? The asset deterioration due to operational inactivity reduced asset value by 5,000 to 7,000 crore. Legal and administrative cost, including appeal, added 75 to 100 crores to the resolution cost. Prolonged CIRP affected potential recovery by 10 to 15%. So obviously this was very prolonged CIRP case. I mean 850 plus days it took. So again, obviously it will add a lot of cost and the recovery would be very, very less. And this has happened in this particular case. Finally, what was the outcome? The process took over 850 days with JSW Steel resolution plan finally approved. Although creditors recovered a substantial amount, delays impacted the ultimate recovery rate and the asset value. So what are the final outcomes or the efficiency insights which we can have from this particular case? First is We should have a framework for rapid bidding process, a clear process for addressing competing bids and limiting the appeals could expedite future resolutions in highly competitive cases. So this is something which we all can, keep in our minds and have a framework, internal framework for this particular thing. Regulatory coordination mechanism. Improved coordination with regulatory bodies during CIRP would help address legal or fraud related issues without causing procedural delays. So for this, I think regular communication is required, and again, time meetings, and you have to be very transparent with the regulators. Then only we can achieve this kind of thing. The next case is Aircel Limited. The background of the case is Aircel Telecommunication Company with a debt of over 50,000 crore filed for insolvency in 2018 after failing to pay creditors amid intense competition in telecom industry. What were the reasons for its delay? Disputes among the creditors. Given the telecom industry regulatory complexity, multiple creditors, including spectrum lenders and vendors, had conflicting claims, delaying consensus on the resolution plan. Second reason for the delay was asset valuation challenges, as we all understand here. Aircel's key assets included the spectrum license, which were challenging to value accurately, causing delays in COC approval. Then there were legal challenges over spectrum rights also. Disputes regarding the transferability of spectrum assets required legal clarification, which added further procedural delays. Let's discuss the fact sheet of this particular case. Outstanding debt was 50,000 crores. Liquidation value was minimal recovery expected. And then delay, it had exceeded, 330 days. Estimated loss due to delay. Spectrum value, depreciation and operational shutdown led to the estimated loss of 8,000 crores in potential realizable value of the assets. Legal and regulatory hurdles added at least 100 crores in the cost. The prolonged process led to job losses and economic ripple effects, further complicating the recovery procedures. So all this, ultimately, when it went to this liquidation, obviously the employees involved there, they have lost their jobs, and then ultimately the economic effect was not very soothing. So ultimately, these kind of cases, we can all understand what was how these delays add to the lesser recovery, and it adds more and more to the losses. Then what was the final outcome? Aircel's insolvency process exceeded the 330-day timeline, which we all can understand, with the liquidation process subsequently initiated due to the lack of a viable resolution plan. The inability to resolve creditor disputes and valuation issues reduced the chances of recovery. Ultimately, the learning outcomes from this particular case could be sector-specific guidelines for telecom. So again, we all know that till date, there are no sector-specific guidelines issued by IBBI. So since there are, for real estate, again and again, it is said that there should be a separate framework. Similarly, for telecom industry, you should also have a separate framework, because again, the valuation, the licensing, or the regulatory authorities, they will have issues one or the other. So again, sector specific guidelines should be established in order to reduce these delays. Regulatory clarity on spectrum should be there. Clear policies on spectrum transferability and valuation could prevent procedural delays in telecom insolvency cases. The last case which we will be discussing is the Reliance Communication Limited case, that is ARCOM. ARCOM telecommunication giant owed over 45,000 crores and entered CIRP in 2019. With critical assets like spectrum and telecom infrastructure, the resolution process was expected to be complex. What were the reasons for delay? Multiple appeals by creditors and operational disputes. That was very much obvious. The COC faced numerous appeals by operational creditors over distribution of receipts, creating lengthy delays in the process. Then regulatory scrutiny on spectrum valuation, just like the previous case, here again the valuation was again a point of discussion. Spectrum valuation emerged as a significant point of contention with government agencies involved in the approval process. Then there was also a lack of industry specific framework. This we have already discussed. So here the fact sheet, it clearly lays down that outstanding debt was 45,000 crore, and the delay, as it is mentioned here, is that it has exceeded 600 days to resolve the overall situation. Estimated loss due to delay, depreciation of the telecom infrastructure and spectrum assets reduced recovery potential by 6,000 crores, and it means a lot of amount. Prolonged legal disputes added an estimated 100 to 150 crores in litigation costs, which is, I mean, similar in each and every case which we have which we have just discussed. Employee layoffs were there, and the market uncertainty during the delay further eroded the operational value of this particular corporate return. Then what was the final outcome? The CIRP exceeded 600 days, which delays significantly reducing the value of RCOM's asset. The case is still ongoing, highlighting the procedural difficulties faced in complex telecom insolvencies. Efficiency insights which we can see from this particular case. Telecom specific insolvency provisions, since they are not there, so it is similar recommendation from just like the previous case. And limit appeals from non-financial creditors. Restricting the scope of appeals from non-financial creditors could streamline COC decision making in future cases. So these are all the recommendations or the suggestions to the regulatory authorities as well as to the insolvency professionals, which they can keep them in mind while proceeding with these kind of situations if you ever come across while dealing with your assignments. Next, we will be discussing about the Indian insolvency scenario and the global insolvency scenario, or what are the practices adopted globally. So we will be comparing the two, and wherever, see, this is not in our hands to change the regulatory framework, but again, we can be aware of the situations or the procedure which the other countries are following, and sooner or later this will be taken up in the Indian IBC scenario as well. So in Indian IBC, what is the object? It is time-bound resolution process, and it obviously projects to maximize the asset value and ensure equitable treatment of the stakeholders. On the other hand, in the global scenario, similar objectives are there, though emphasis varies. For example, in the US, here the US focuses on the debtor in possession model, while UK prioritizes the creditor recovery process. Second basis of difference is the insolvency framework. There is a single code consolidating corporate, individual, partnership insolvencies, though we are not, all that has not been, started as of now. Till date, only the corporate insolvency is happening. But sooner or later, that will also come into existence, the other parts. On the other hand, in the global scenario, fragmented in many countries. So there is no particular or a single code. For example, the US has separate chapters under the bankruptcy code. EU countries follow UNCITRAL guidelines. Then what are the various key features in Indian IBC? As we all understand, there is a moratorium during CIRP, time-bound resolution process is to be there. Then it is COC-driven process, liquidation is the last resort. While in global scenario, in case of US, Chapter 11 allows debtor in possession control. Then in UK, administration prioritizes company rescue. In case of EU, they focus on pre-insolvency proceedings. Then what is the role of debtor in Indian insolvency scenario? So debtor loses control of management during CIRP. Resolution professional takes that over. In global scenario, US, for example, debtor retains the control because the model they are adopting is DIP model. Then next is UK or EU, administrators or trustees often replace the management. Next basis of difference could be on the stakeholders prioritization. In Indian scenario, secured creditors have highest priority, followed by workmen dues, operational creditors, and shareholders. While in case of global scenario, similar priorities there, but with variations. For example, in the US, unsecured creditors play stronger role in creditor committees. Then there are different bases there are differences in the case of creditors control. Then time frame could be one of the major point of difference here. Like if we read this time frame point in an Indian scenario, as we know that CIRP is to be completed within 330 days, though delays are very much common. Then in global scenario, in case of US, there is no fixed time. Cases may last in years. For example, in case of Lehman Brothers, it has happened that way. In UK or EU cases, they focus on pre-pack sales for speedy recoveries. Then, moratorium also, that could be one of the that could be a basis of difference here. In Indian context, automatic moratorium during CIRP to protect the debtor from suits and asset seizures are there. While in case of global scenarios, similar moratoriums exist, but the rules may vary. The US automatic stay is more comprehensive. They are doing it that way. Then in case of group insolvency, in Indian scenario, there is no formal provision as of now. Cases are still dealt independently. While in case of global scenario, in case of US, substantial consolidation are there in certain cases, while in EU they adopt the framework or they follow the framework which is there in UNISTRL. So basically, if we deep dive into the United States Chapter 11 bankruptcy, the role here is creditor committee have a similar role just like us, although the judicial oversight is typically less restrictive, which can make US resolution more predictable, but potentially it takes a longer time. So timelines here, they have mentioned that while in Chapter 11 proceedings in the US, they do not have any fixed statutory timelines like IBC. There are procedural rules to ensure cases proceed efficiently. What about the flexibility there? Courts have discretion to manage the timeline based on the case complexity and circumstances, aiming for a balance between expediency and fairness. So, they can change the timelines also. So the courts have the discretion there. Then in case of United Kingdom, administration and liquidation rules and regulations, what is their role? The UK's administration regime under the Insolvency Act allows administrator to act quickly to protect assets, sometimes without needing creditors' approval also, which can expedite resolutions but may sometimes marginalize certain creditor groups. So they can take control in their possession, which is not there in our case. So this is a complete different scenario in UK. What about the timeline? The UK insolvency regime emphasizes early engagements and sets out specific timelines for various stages of administration and liquidation. Then regarding enforcement, timelines are generally enforced strictly to maintain creditor confidence and ensure timely resolution of insolvency cases. But it is not just that in India only we are having the delays. It is a global thing. Delays are there in different countries, different insolvency codes, whichever country it is. But again, the framework is somewhat or the other different. In Australia, there's a concept of voluntary administration there. What is their role? Australia's voluntary administration process does not traditionally prioritize the unsecured creditors like home buyers, which sometimes leaves individual creditors vulnerable if no buyer is found for the insolvent company's asset. What are the timelines set for this kind of cases? The Australian system provides fixed timelines for voluntary administration, including periods for creditor meeting, reporting, and resolution planning. So they have set a fixed timeline for everything. Regarding adherence, courts emphasize adherence to these timelines to prevent undue delays and facilitate efficient restructuring or liquidation. And in Canada also, similar situation is there, but there is flexibility in managing unique creditor classes, often through the court-appointed monitors who mediate and prioritize the claims. Similarly, there's a case in Germany, but they favor liquidation more if a company's viability is in doubt, with a structured yet quick process to prevent value erosion. Then in case of Japan, Japan's Corporate Reorganization Act also allows courts to liquidate companies that cannot demonstrate a viable restructuring path early in the process. So again, they are not, wasting time in finding out the resolution applicants. If they are of the view that it is better to liquidate, if the project is not viable at all, then they follow this path. Then in case of European Union insolvency regulations, they have flexibility in timeline, but again, structured oversight is also there. What are the key takeaways for us through all these cases and the things which we have discussed? First is we should expedite our decision making. We should adopt strategies that minimize litigation and reduce procedural bottlenecks. The next key takeaway could be standardized valuation. So again, these valuation takes time, and these are a major thing which may lead to disputes also at times. So valuation methodology should be discussed in advance, and COC should be kept in confidence with the valuers, so that later on they do not disagree with the valuation. So emphasize fair and transparent valuation practices, particularly for large conglomerates. That is very, very important. The next is to adopt the digital tools. So as we know, nowadays without AI, if it would be like you can keep working and working, but if you use these digital tools or if you use this AI, then it will make your life very, very simple. So it is advisable that you should always try and figure out what tools you can use in efficient manner to reduce your work burden. So leverage case management tools for more efficient stakeholders communication, particularly with diverse or large creditor bases. So there should be a habit to use some kind of these digital tools. Like there is a CIRP calculator wherein you can have all the dates in your hand at the initial stage itself, so that later on you do not have to keep checking again and again. So it is always better whenever there if any case is admitted, at the same time you should have all the dates in front of you, and you should keep monitoring also whether you are following that timeline or not. And if there is any kind of delay, again you should communicate, and you should take proper measures to address all those situations. So what could be the steps to mitigate the challenges which we have seen so far? Though see, everyone who is into the field, who is practically doing doing all these assignments, is very well aware how to mitigate the challenges. You already know how to perform in an efficient manner. But again, sometimes it happens that the work burden does not allows you to foresee the things, or you are not able to figure out the possible solutions. So these are a few recommendations which can be of help. And of course, a teamwork is required for all to manage each and everything in insolvency cases. First is efficient time management. So prioritizing the task and managing the time effectively to ensure adherence to the timelines. Then second is stakeholders engagement. Regularly engaging with the stakeholders to manage expectation and ensure smooth communication. So that is the key. I mean, communication is the key. If you keep regular interaction with your stakeholders, then it is possible to come out to the resolution very, very fast. The next is expert assistance. Wherever you feel like you can appoint any professional or any expert for your assistance, that is all provided in the law, and you can take their help, and without any, wasting your time into that situation, you can always seek help from the experts. Seeking assistance from legal, financial, and operational experts to navigate the complex issue will make your life easier. The next is technology utilization. This we have discussed earlier also. So leveraging technology for better claim management, record keeping, and communication. Nowadays, various softwares are also developed to work this whole insolvency process. So you can delve into that also, or if you want, you can seek help from others also. That is also possible. So special attention is required in the following situation. First is strengthening the COC's role. So this is a recommendation, and obviously we all want that the role of COC should be enhanced rather than placing everything to NCLT or the regulatory authorities. So it's better that COC should have power to they should be the governing they should be the governing authorities to finally decide what is good or bad for them. So empowering COC, reduce judicial interference, streamline decision making. Then training of COC members is also recommended here. So improving understanding of insolvency law and strategic decision making will help COC members to take timely decisions in the matters. The next is improving valuation standards. Again and again, this valuation, we have seen in all the earlier cases that this is one of the reasons for delay, the valuation aspect. So there is an utmost need to improve the valuation standards. This is what we can recommend, and of course, we should also have a fair idea of these valuation standards and how they work. Then adopting global valuation standards, use standardized valuation frameworks for transparency. That would help to mitigate the delays, then reduce the delays. Next is technology driven valuation. So leveraging AI tools for real-time market valuation will obviously reduce the delays. The next is digital tools and technology, automation and case management, use of digital platforms to streamline communication and compliances. That is something which you all can adopt. The next is global best practices. Examples from Singapore's digital insolvency registry and US case management tool. You can always check what the other countries are doing for as a best practice. You can always adopt those strategies in your cases also. Next is fostering judicial training and efficiency. So again, specialized IBC courts here are recommended to encourage dedicated to have IBC benches to fast track the resolution process. We need to have dedicated IBC benches to avoid these kind of delays. Next is cross-border insolvency provisions. Implement UN's model law on cross-border insolvency for efficient handling of global cases is highly recommended, and a special attention is required for the cross-border insolvency cases, and a lot of effort is being put into that area also. So now later we will all have that. Next are again a few recommendations. First is the enhanced legal and regulatory framework. See, this is timely recommended again and again through these forums. What are the best ways we can use the IBC and maximize the asset valuation? So first is the timely legal support. That is highly recommended here. So engage experienced legal counsel early in the process to navigate complexities and expedite the legal proceedings. Next is regulatory clarity. Work closely with the regulatory bodies to seek clarification and streamline compliance requirements. Next is effective operational management. This is also one of the recommendations. So due diligence and due process. This should be everyone should conduct thorough due diligence on the corporate debtors operation, financials and assets to identify key issues and streamline the resolution process. Then specialized teams should be there. Assemble a team of experts, including forensic auditors, legal advisors, and turnaround specialists to handle specific tasks of the insolvency process. See, it is again and again recommended, don't keep everything to yourself, because a single person obviously cannot resolve all the matters of corporate debtor. So again, then the law is asking you to engage more and more of specialized person, experts, wherever you need help. So obviously you can take their help and you resolve the issues timely. So that will obviously help you out. Next point to mitigate all these challenges could be the financial and resource management. As we earlier also mentioned that funds are very much required if you want to keep the process ongoing. So working capital management should be there. So secure interim financing to maintain the business as a going concern. Engage with the financial institutions and potential investors to ensure continuous funding. So this is a recommendation which you can, whenever funds are required, you can always talk to COC that rather than going to outsiders, why don't you contribute? So interim finance can be taken up from them also. Cost optimization. Implement strict cost control measures and seek cost-effective solutions to manage the CIRP expenses within the budget. See, we all try for this, but again sometimes the things go beyond budgets. So again it is just a recommendation to optimize the cost as much as possible. Next recommendation is the stakeholder engagement and communication, because again don't keep things to yourself. Kindly communicate it to all the stakeholders, COC, and get proper resolution for all the things. So regular updates should be there. Maintain transparent and continuous communication with all the stakeholders through regular meetings, updates, and reports. Conflict resolution should be there. Even if there is any conflict, that has to be resolved. Otherwise, it would add to the delay only. So facilitate mediation and negotiation sessions to resolve conflicts among the stakeholders and ensure consensus on key decisions. Next recommendation is strategic planning and execution. So formulating viable plans, collaborate with industry experts to develop realistic and sustainable resolution plans that maximize value for the creditors and ensure the viability of the business. Then negotiate with the bidders. Whenever there is a resolution plan in your hand, then you should always try to negotiate with the bidders. Conduct competitive bidding process for the assets. If you are if you have put the assets for bidding, then obviously you have to conduct a competitive bidding process for them. Then negotiation with the resolution applicant to secure the best possible outcome for the creditors, because ultimately the object is to maximize the value of the assets, and ultimately you are a channel between the resolution applicant and the corporate the COC. So finally, ultimately, it is in your hands that before the resolution plan goes to COC, firstly you negotiate with the resolution applicants and get the best plan for them. Next option, again, as we have discussed, that you can leverage the technology and data analytics. There are various tools available which you can use in your day-to-day life to make the things easier. Automation, use automation tools to reduce manual efforts, minimize errors, and improve the efficiency of the CIRP process. Then capacity building and training. So these sessions obviously they enhance the capacity building exercises, and then again you should allow your staff also to participate in such sessions, or you should always train them or keep them abreast with the new or updated guidelines or the various regulations which are time to time issued by the IBBI and all. So proper training should be there for each and every one of us, so that we can complete the task in time, and we should be updated with the recent judgments also, so that we can properly handle the situations. So continuous learning is advised. Provide the training and capacity building programs for RPs and their teams to stay updated with the latest developments in insolvency laws and practices. Then best practice exchange, that knowledge sharing session should be there, so that you can all share or guide each other, share your experiences with each other, and guide also in some situations. So that's it from my side. We are open for any questions if you have, or if you want to share any experience of yours, because this was a very theoretical kind of topic. See, as I have already said that delay is obviously not, sometimes situation is not in our control, so delay may happen. but it is always better to plan it in advance and take clue from all these cases how we can better manage ourselves and proceed for any of the assignments. Anyone, if you want to share your experience, we are open to that. Ashish sir, would you like to share something? Ashish Kumar ji Jain.
No, ma'am, nothing. Thanks. May I say something?
Yeah, sure, sir.
Right, I'm Sanjay Khandelwal.
Yes, sir.
I just want you to, say something about, many times we are bound by the strict guidelines prescribed in the regulations. And the real situation, you see, the practical things that we are facing compel us to take a decision which is not strictly within regulations.
Right, sir.
Maybe, we are giving some kind of a flexibility to the resolution applicant or some other thing that we are strictly not required to give by regulations. Now, considering the practical aspects, we are doing it. How to protect ourselves in these situations?
As you have rightly mentioned that sometimes we are not, doing the things according to the regulations, just to, ultimately our intention is for the benefit of the corporate debtor ultimately. So sometimes it happens that, again, the thing is, what I would say is proper communication has to be there. So you have to involve the stakeholders if you are allowing any resolution applicant, if you are giving them some more time or something, you should always keep your stakeholders involved. You should have a proper guidance from the COC also. I mean, whether they are allowing that or not, because you cannot take everything on yourself. It's better to, keep everything transparent.
Madam, let me give you an example so that you're able to better appreciate. You see, real estate cases where we have members of the COC comprising of allottees. Now, these allottees may not necessarily have the required expertise. And you see, going to them for all decisions, many times it creates more noise and less concrete. So you see, we have to ensure that, when our object is to resolve a company for the benefit of everybody, just hearing to noise will further delay the process. So supposing I write to all the members in the real estate group who are comprising 400, 500 people, and I receive 300 emails, and I'm not able to take a decision. So see, that is a real issue in real estate. What do you do there?
So as one of the recommendation was to, have a proper training mechanism, or you need to guide the others also. So whenever there is a situation like this, firstly, the law should be known to them, because sometimes it happens that people are not aware of the law. There is a strict timeline, they are not aware of it. They are, like home buyers, they are concerned with their money or whatever they want to receive. They are concerned with that. So firstly, we should make them aware that there is a guideline, there is a proper procedure which we have to follow. So accordingly, obviously some of them will understand, others may not understand, and it is not, our duty to make everyone understand. It is not like that, but it should be our responsibility that we must first let them be aware of the proper procedure which is there, proper timelines which are there, and looking to the timelines, what could be the best decision that we must ask them simply. Obviously, sir, we are not there to make everyone understand. That is not at all possible also. And as you are saying, it will create noise in most of the cases. So when people are not understanding the basic issue, when they are not aware of the proper law, they will not hear to you also. So firstly, we should make them aware about the law in summary form, maybe that these are the provisions and this is the best within the restricted timelines. What best we can do combinedly, we should follow that. This is what I would say. So
Right.
if possible, meetings can be arranged with them. See, we cannot have everyone at the same platform. But again, on your part, to be on a safer side, that you communicated it to them, you can always show that you planned the meeting, maybe twice, thrice, or whatever time you planned the meeting, but maybe the quorum was not there or whatever. At least you have that documented with you that you tried your level best to do everything.
Right.
And
So,
ultimately, what happens is.
right. So I agree with you. And having done all of this, despite having done all of this, you see, you still can't
We cannot
stop the
ensure anything,
voices.
sir. We cannot
And
assure anything,
yeah,
right?
you can't assure. And then you see, you are open to a lot of regulatory action from the regulators, is where the risk lies. So this is something that the institutes must, the IPAs must bring forth before IBBI, that you see, this is a real-time problem faced by in real estate cases, where there are 400, 500 people who, despite your explaining to them, are not being able to appreciate the situation because, of course, many of them, like you said, are interested in money, the recovery of their money. So you see, it's very difficult for us to explain to them. And you see, you are always very, very open to actions by IBBI and the IPA, which is precisely what I would like to bring forth here. Of course, you don't have an answer to this, neither do I. I can understand that. But this is something that we need to realize.
I mean, these kind of platforms give an opportunity to at least share the experience, and we can, summarize a few key things out of any session, and then we can post that to the
Right.
regulators
Right,
so that
right.
they can have it on their record.
Precisely my point. Thank you very much.
Thank you. Anyone else who would like to say? So we can wind up the session if there is no one, if we don't have any questions.
Okay, ma'am.
Hello.
Well, I can see Mamta ma'am is there. Then I would like her to speak.
Hello, ma'am. Sorry for
Rajesh
delay.
sir. Yeah, Rajesh sir.
Ma'am, a small query. Actually, I'm handling a CIRP of a very small company with only one member operational character as a COC. So, actually, after appointment and I initiated all the initial steps as were required by IBC. Thereafter, the CD filed appeal again in the NCLAT, and as COC is required to fund further for furtherance of IBC proceedings, I need to appoint like valuers and publish Form G. But he is saying that if I spend more, I don't know the fate of this appeal. And if it is my dismissed, so and you keep in abeyance till that is decided. So actually, it is being so there is time lapse, timelines being elapsed. So I have actually filed a application to NCLT to seek directions to the COC to arrange interim finance for the process. So what should I do? I should I spend from my pocket to proceed or wait? Because a timeline for Form G has already lapsed. I have appointed valuers, but don't have money to pay them. So what do you
That is
advise?
a very practical issue, sir. That is a very practical issue. But I don't think here the IPs are paying out of pocket in most of the cases. So
Yeah.
I
So, what is your opinion? Without any, you're taking it on
But the
record.
case
I'm just, as a fellow professional, I'm just asking.
yeah, sir. If you are not feeling that the client will pay, then I don't. I mean, I would not suggest to pay out of pocket first of all. If you think that something can happen in that particular case and you are very much sure that you should go ahead, then of course that is your inner call. I mean, but if you think that ultimately nothing will happen in this particular
Otherwise, I can actually naturally NCLT takes time. I have filed the application a month ago. It is not listed yet for the hearing. So, should I move one more application to NCLT to make me clear that I'm approaching?
Of course, that you can do, sir. Anytime you can do.
So, this time limit has elapsed only because he's not cooperating.
Yes, that you can put on record. That is for sure you can do.
Yeah, once I have put on record a month ago that in COC I have been from IRP I am to RP, and then I sent I have appointed two valuers and for this process, and that was done within time. But after that, I'm not able to proceed. So I have already put on record on NCLT. I don't think there will be any complications. For compliances, I don't know. Like
All these costs are in as a part of CIRP costs, sir. So whatever you have spent so far, you will be able to.
yeah, I got some initial amount from COC as was directed by NCLT. Actually, I was appointed by NCLT only. So that I got, but that got spent in a month.
I mean, this is a very practical, genuine issue, sir. So, I mean, whatever your inner feeling is for that particular CD, it varies case to case. You cannot. I mean, I will not be able to make the decisions for you.
Yeah. I can understand. I can understand. Thank you, ma'am. Thank you.
Well, Mamta ma'am is here. I would like her to say something. Mamta ma'am, are you there? Even I just want to say something here that even if as mean there are a lot of difficulties, there are a lot of problems, still the charm of insolvency professional is still there. There are a lot many people, they are studying and appearing for the examination, and in real life we all understand how difficult all the situation is, but alone obviously we cannot handle each and everything. Of course we have to seek help either through IPEs or wherever. So, I mean, though this is an emerging field, you should not quit. There are problems, but again, time will heal everything. So, it is also that we should be capable enough to, plan it in a better fashion. But wherever you seek that there are more problems than solutions, then you should quit, I would say, for that particular assignment. Can we wind up the session, Anjali ma'am?
Sure, ma'am. Sure, ma'am. If there are no questions from the participants, then we can wind up the session.
Okay. Thank you so much for
Thank
your
you very
patience
much,
hearing.
ma'am, for such a nice session and for sharing your so much knowledge and experience with all.
Thank you,
Ma'am,
madam.
please share your PPTs.
Sure. I'll do that.
Now there is lunch break till 2 p.m. Next session will be taken by Sucheta Gupta, ma'am. We will reassemble at 2.
Thank you, ma'am. Thank you.
Thank you, ma'am. That was very interactive and fabulous session. Thank you very much.
So the topic was, I mean, that was like more of, it is emotional topic, I would say, that delays are there, but still we cannot handle everything. But whatever is in our part, we should do that. That is it. And if
Thanks
we
a
have
lot.
taken this profession, then of course we should, give our best to it. That is it. Thank you. Thank you, everyone.
Yeah, thank you. Thank you, ma'am.
Thank you, Ji. Thank you.
Good afternoon, all. Shall we start now?
Yes, Anjali, go ahead.
Good afternoon, everyone. Now the session will be taken by Sucheta ma'am on the topic pre-IBC resolution, role of mediation in Section 9 applications. Let me briefly introduce Sucheta ma'am. Ma'am is CS, IP and lawyer. She is currently associated as consultant with Advopant Legal Services law firm since 2016 till date and in another firm of IP. She is also having on CS peer reviewed firm named Sucheta Gupta and Associates. She has worked in the areas such as IBC, SURFACI Act, Trademark Act, Company Law, Secretarial Audit, Listing Compliance, Legal Drafting, FEMA, Taxation, Finance, Accounts and Income Tax. Now, ma'am, please start your session. Ma'am, you are not audible.
1 minute. Okay, thank you. And now, am I audible?
Yes, ma'am.
Okay, thank you. Thank you, Anjali, and welcome to all the participants. And thank you to the ICSI IPA who has provided me today's opportunity to speak on the topic. And this is very relevant topic. So let's begin with this topic. I just sharing my PPT. 1 minute. Have you seen the PPT?
Yes, it's visible.
Okay. Okay, so the topic name is, as you all are aware, that the pre-IBC resolution and the role of the mediation in Section 9 application under the IBC. So before starting the main topic, we should know, as you all are the seniors and IPs are there, who is attending today's webinar. However, I will make some brief history of the IBC. So the IBC, there is a brief, I'm just making a brief background history of the IBC, because there are so many legislations are there, as the Companies Act, the SICA Act, the SURFACI Act are there, the recovery of debt due is there. So there are so many acts which was specifically provided the recovery mechanism. However, why the IBC, there is a need was felt by the legislation to introduce the IBC. So basically, this is a timely solutions has to be provided. And the next motive of the IBC is that the maximization of the assets value of the corporate debtor. So basically, the motto of the IBC is there that the timely resolution and the assets, the valuation of the assets of the CD should be maximized. So the first case, as you all are aware, that first of all, this was applicable from 28th May 2016, when at that time Mr. Pranab Mukherjee was there as the president who was giving the assent on this act. And this was come into force in the notification in the official gazette on 28th May 2016. And the first case which was decided by the NCLT is the Synergies Dure Automotive Limited case. And the first case which was decided by the Supreme Court is the Innovative Industries Limited versus ICICI. So this is the basically brief of the IBC. And before this, you know that some other acts was applicable, but when IBC coming into force, these acts has been repealed. So these are the acts: the Presidency Town Insolvency Act was repealed, the Provisional Insolvency Act was repealed, but there is a required, some requirement is there to make some amendments in some other acts. So the SICA Industrial Companies Act was amended, the recovery of debt due to bank and financial institution was amended, SURFACI Act was amended, and Companies Act was amended, and there are some other acts are also there, the acts which was amended. So this is basically what is the applicability. First of all, we should know where it is applicable. IBC is applicable for the corporate entities also, as well as the non-corporate also. But however, there are in fact there are 255 sections in the IBC, but and 5 parts are also there. But this third part, which is applicable for the individual and partnership firm, this is still not into the force. However, there are some personal guarantors insolvency was provided in the act. The regulations are there. So personal guarantors insolvency process can be initiated. So basically, the first the scope in the IBC is there. We can go for the CIRP process if the company is there. We can also initiate the pre-packaged insolvency process and the liquidation if the company is not able to pass the resolution plan. If this is not approved by the by the creditors, then company go for the liquidation. And the voluntary liquidation has also been provided in the act, and we can go for the voluntary liquidation. And the bankruptcy is applicable only for the companies, only for the partnership firms and individuals. So liquidation is for the corporates and bankruptcy is for the non-corporates. So this is the main applicability of this act, and regulator, you all are aware that the IBBI is the main regulator, and under the IBBI, the IPA is registered. Like 3 IPAs are there, like ICSI IPA, ICAI IPA, and the ICMA IPA is also there. And we as a CS, we are registered as a IP with the IPA. So IPs and the information utilities, these are the main regulators. And adjudicating authority, you all knows that NCLT is the main adjudicating authority in case of the corporates, and debt recovery tribunal is the tribunal is the adjudicating authority in case of the non-corporate entities like individual and partnership firm. So this part, if this part will be applicable, this part, this will
ਕਿਉਂਕਿ ਉਹਨੂੰ ਅੱਛਾ ਉਹਨੇ ਨਾ ਇੱਕ ਚੇਂਜਿੰਗ ਦਾ ਵੀ ਉਹ ਨੋਟ ਵਿੱਚ ਹੈ ਮੈਂ ਉਹਨੂੰ ਕਹਿੰਦਾ ਤੂੰ ਲੈਜਰ ਤੇ ਭੇਜ
Am I audible? I think there was some connection error in the network. So it's my apologize.
Yes,
So
yes.
am I audible? Now
Yes.
I just, okay, I'm sharing the PPT. So basically, first of all, we should know the Section 9 application. What is the Section 9? What is the Section 9 applications is there in IBC, which is provided. The first step is there. First, we should require to send the demand notice, as the forms was also provided as per the IBC. And the second step is there that the reply, the time of 10 days should be given to the corporate debtor, and the corporate debtor have required to submit its reply within 10 days. And if it is agreed to make the payment, then there is no matter to file the Section 9 application. And if debtor has failed to respond, or if there is a validity of dispute, then the claim have required to be filed by the applicant in the application Section 9 application with the NCLT. So this is the main steps which is involved in filing the Section 9 application. And this is up to the tribunal that it will evaluate the application, that the what is the facts of the application, is there any disputes is involved in the application. So the NCLT will evaluate the application, and after evaluating the application, the NCLT will admit the application. So this is the main steps which is involved in the Section 9 application. However, there are some key challenges in Section 9 application. What is the key challenges are there? Suppose if we have initiated the CIRP process against a company, and the main purpose of the creditor is there sometimes that they only want to create some pressure on the corporate debtor, rather than as a legitimate recovery. They want to create a pressure on the corporate debtor by filing the Section 9 application. So this is the key challenges. There are some other key challenges are also there. When the application has been admitted, and the Section 9 application, when it was filed, and the section was the application was admitted, then there are some you all are aware, the all the control of the management has been given to the IP. So the company management have lost its control. And what problem will create at the time, that the business operations cannot be continued in a proper way. However, and if Section 9 application has been initiated, then there are some credit risks are also there, that the reputation, because no one want to give any loan to such type of company, or no one want to give any finance to this type of company who is in the CIRP process. So basically, this is also create a risk on the credit of the corporate debtors. And delay in admission, you all know ki if there are so many application has been pending before the NCLT till the date, and there is a delay in admission because of the overburden is already on the NCLT, and there are so many cases like progress report have required to be filed to the NCLT, preliminary report have required to be filed. There are so many steps involved in the CIRP process and liquidation process, in which the NCLT is the we have required to report on the to the NCLT. So there are so many cases is already going on there. So this will create the overburden on the NCLT. And what a problem is there also, insufficient resources. Because I have seen in Allahabad NCLT bench, I was visited last week, met with the all two judges there also. there is I have seen the infrastructure of the NCLT. There is a very small office is there. I think the light is also not proper. Lighting is also not there properly. So there are some issues with the infrastructure which is provided to the NCLT is also there. So this create the bottleneck and preventing the efficient resolutions and the costly legal proceeding. As you all are aware, when we initiate the CIRP process, first of all, the IBBI has mentioned that the minimum fees structure has been mentioned for the IPs. And when we initiating the CIRP process, the legal fees, the litigation fees is also there. So this is the costly legal proceedings are there. If any application has been initiated under Section 9, or there is the absence of pre-insolvency mediation operations. So this options is not available. So these are the main key challenges in the IBC. So the legislations have felt that there is a need to make a pre-resolution, the pre-IBC resolution, pre-litigation should be there in the form of the mediation. So before discussing Mediation Act, I will just show you the discussion paper which was issued by the IBBI. I just share this paper also. One. So, is this visible, the discussion paper? Have you seen this? All the participants, please reply.
This is not visible. The list of documents is visible.
1 minute, sir. I'm just trying to share the screen.
Particular document
Yeah,
is not
yes,
visible.
yes, I'm sure. Is this visible now?
Yes, now it is visible.
Yes.
Okay, thank you. So this was the discussion paper on mediation, which was issued by the IBBI for our comments. And what is the main issue which was involved in this, the proposal which was made by the IBBI? It is proposed to have that an option of mediation can be exercised by the operational creditor may. Here is the word has been can be exercised, means can be exercised by the operational creditors before filing the insolvency application under Section 9 of the IBC. So this is the pre-litigation. This exercise cannot be executed after filing the application under Section 9 application. This is the preliminary steps which have required to be made before filing the Section 9 application. So the operational creditor can undergo the mediation with the aid of the mediator as provided under the Mediation Act 2023. In case of failure of mediation settlement, if they have not succeed, the corporate debtor and creditors will not succeed in the mediation settlement, then the mediator will prepare a non-settlement report which shall be annexed with the application for initiating the CIRP before the adjudicating authority. So when we file this application, the application which we have discussion to annex a report, the settlement report. Is my PPT is visible now? Have you seen the PPT? Sir, please reply to all the members.
The PPT.
Yes,
I can see.
it is visible.
Yeah. So, the discussion paper itself provides that we should annex a settlement report. We should annex the settlement report for filing for initiating the CIRP process as per section 9. So if we want to file any application as per section 9, then we have required to annex this mediation report along with the mediation as per the Mediation Act 2023. Now we'll discuss the Mediation Act. What is the Mediation Act and how it will come into force? The Mediation Act was received the assent of the President on 14 September 2023 and it was came into the official gazette on 9th October 2023. So since the 9th October 2023, this Mediation Act was applicable. And what is the purpose of this act specifically is provide for online mediation. Online mediation option is there as acceptable and cost effective process. This is the cost effective process is also the will be made if all the proceeding will be initiated as an online process through the online process, then this automatically will become the cost effective process. So in the Mediation Act, where is it is applicable? It is applicable to whole of India. So the Mediation Act is applicable for both the whole of India. The Mediation Act shall apply where the mediation is conducted in India and all or both the parties habitually resides in or incorporated in or have their place of business in India. So basically, the party should have their place of business in India, so the mediation can be initiated in India only. The mediation agreement provides that any dispute shall be resolved in accordance with the provision of the act or there is an international mediation or wherein one of the parties to the dispute is the central government, because the central government and state government and other agencies or public bodies or corporations are involved if and controlled and owned by the such government, then it is specifically provided if where the matter pertains to the commercial dispute, this should be decided by the mediation only. So this is specifically provided in the Mediation Act. And or is there to any other kind of dispute if deemed appropriate and notified by the central government or a state government from time to time. So basically the discussion paper is invited for our comments and 24th November is the last date for submitting our comments on this. So what notification they have drafted? Basically, this notification, the new regulation, section 2BA, they have drafted section 2B, regulation 2BA. After 2B, they have drafted new regulation 2BA in insolvency resolution process of the CEO corporate person regulation 2024. In this regulation, they will make the changes and 2BA new regulation will come into force. What provided in this new regulation? That an operational creditor may undergo the mediation with the corporate debtor for resolving the disputes of commercial nature in accordance with the provision of the Mediation Act 2023 before filing application under section 9 and thereafter. So they have mentioned that the corporate commercial if dispute of commercial nature, they have mentioned in this section basically. However, we all knows that if we have filed any section 9 application, what is provided as per section 9 subsection 5D of IBC 2016. This is provided that adjudicating authority can admit the application if no notice of dispute has been received by the operational creditor or there is no record of dispute in the information utility. Basically, this was provided as per section 9, subsection 5, clause D However, the legislations have framed their regulations and they have saying an operational creditor may undergo the mediation with the corporate debtors for resolving the dispute of commercial nature. So if the dispute is there, then how can go for the Section 9 application? So so this is the main problem in this regulations which have required to be discussed. However, before discussing the taking the comments of others, we should go to discuss the Mediation Act in a proper way. So as we have seen that the commercial dispute word has been used. So what is the meaning of commercial dispute basically provided as per the Mediation Act 2023? The section 3 subsection A of the Mediation Act provides what provide commercial dispute means a dispute defined in clause am I audible now, sir?
Yes, you are audible.
Okay, thank you. So the commercial dispute, what is the meaning of commercial dispute basically? This is provided as per the Mediation Act, means a dispute defined in clause C of subsection 1 of section 2 of Commercial Code Act 2015. So this is basically provided as per the definition. Now, what is saying the Commercial Code Act 2015? However, a wider definition provided as per section 21C of the Commercial Code Act 2015, which is provided that ordinary transaction of merchants, bankers, financiers, and traders, such as those relating to the mercantile documents, including enforcement and interpretation of such documents, these are the categories basically which is provided for the commercial dispute as per the Commercial Code Act 2015. So there are the 22 clauses are there. And there is one more explanation is also there. What is provided as per the explanation? A commercial dispute shall not cease to be a commercial dispute merely because it also involves action for recovery of immovable property or realization of monies out of the immovable property. So the immovable, if any dispute related to the immovable property or something, then this can also be assumed as the commercial dispute. And the explanation is also provided shall not cease to be the commercial dispute if there is any state government or the government bodies has been involved. One of the contracting parties is the state or any its agencies or instrumentalities or the private body carrying out the public function. Still this dispute will be considered as the commercial dispute. So basically, the Commercial Act has been provided its wider definition of commercial dispute. If they have used the commercial dispute word, I don't think any application will be admitted by the AA, by the adjudicating authority, if any dispute has been involved, because Section 9, subsection 5, clause D is specifically restrict here in admitting any application which is involved any type of dispute. So there should not be used the word dispute. The dispute of commercial nature should not be included in this regulations. Now, we should also discuss that who is the mediator. This is the main point. Who will become the mediator when, if this Mediation Act will come into force, then who will become the mediator? So section 3 clause 1 of the Mediation Act 2023 provides that mediator means a person who is appointed to be the mediator by the parties or by the mediation service provider. So who will become the mediator? Basically, the parties can appoint the mediator, person who is appointed by the appointed to be a mediator by the parties, means parties can choose, or the mediation service provider, they can choose to undertake the mediation, and includes a person registered as the mediator with the council. So the person should require to be registered with the mediator council. So this is basically the definition who will become the mediator will provided in the as per the Mediation Act. Now the explanation is also given that where more than one mediator is appointed for the mediation, reference to a mediator under this act shall be a reference to all the mediators. Means if there are more than one mediator, then all mediator will be considered as the mediators. Now section 3 subsection M provides the mediation service provider, because we have read that the mediator will be appointed by the parties or the mediation service provider. Now we have required to understand who is the mediator service provider. So the mediator service provider means a mediation service provider referred in subsection 1 of section 40. Now, what is section 40 subsection 1 provides? Section 40 subsection 1 provides that mediation service provider includes, who includes? A body or an organization that provides for the conduct of mediation under this act. Means body and organization both are covered for the conduct of mediation under this act, and rules and regulation made thereunder and is recognized by the council. However, these are recognized by the council also. So basically this is provided. Subclause B is also saying that the an authority constituted under the Legal Service Administration Act 1987 or a court annexed mediation center or any other body as may be notified by the central government. So these bodies, these service provider, they have included, but what they are saying, provided that the bodies referred in clause B, C, D, means this, because here the already saying he recognized by the council, but here they are saying for the BCD shall be deemed to be the mediation service provider if recognized by the council. So they have also saying if these type of authorities are there, then this should also be recognized by the council. So main role is for the council, who will decide whatever the person is registered as a mediator, this will only decided by the council, who will become the mediator. Now, what is the meaning of council? Because we have read that who is mediator, who is mediation service provider. Now, the council will take all the decision. So, who is the council? Now, section 3 subsection C of the Mediation Act provides, what provides? Council means the Mediation Council of India established under section 31. So what is section 31 subsection 1 provides as per the Mediation Act now? Section 31 subsection provides that the central government shall notify. Now the power is giving to the central government. As we have read so many sections in IBC, that the all power has been given to the central government, and after central government, regulations drafting power has been given to the IBBI, and under the IBBI, IPA is there, and under the IBA, IPs and IPE is there. So we have seen that first of all the central government is there, next council is there, then the mediation service provider is there, and after the under the mediation service provider, the mediator is there. So this is basically. Now, what is the council? The central government shall by notification establish for the purpose of this act a council to be known as the Mediation Council of India to perform the duties and discharge of the function under this act. The council shall be a body corporate by the name aforesaid, having the perpetual succession and a formal seal and a power subject to the provision of this act to acquire, hold and dispose of the property. The head office, they have prescribed Where will be the head office of the council? So the Delhi is the main place where the council, head office of the council will be exist, or at any such place as may be notified by the government, or they have also prescribed, or any other place if any notified by the central government. The council may, in consultation with the central government, establish offices at other places in India and abroad. So they have specifically mentioned that the main office, the head office in Delhi or any other place, and other offices can also be established by the council as per the consultation with the central government. So this is the main definition of the council. However, I don't think there is any mediation council is established in India till the date. So this is we have discussed already. The now section 2(3)(h) of Mediation Act 2023 provides कि mediation. What is the mediation? Mediation includes a process whether referred by the expression mediation, pre-litigation mediation. This is the basically the pre-litigation mediation, because they are asking for the pre-litigation mediation, because the recommendation the pre-mediation and pre-institutional mediation. And this was also the ICAI, IIPI, they have given their suggestion on this. So the we can say this is basically the pre-litigation mediation. So before instituting any application as per section 9, we should go first for the mediation. However, this is saying, the act is saying this is not mandatory, may go, because this is specifically provided as per the discussion paper. The operational creditor may undergo for the mediation. This is provided. So this is the voluntary. Now the process will be voluntary. It will up to the parties that they want to go for the mediation or not. So this is the pre-litigation mediation. The Mediation Act itself provides its definition ki what is included in the mediation: the pre-litigation mediation, online mediation, community mediation, conciliation, or an expression of similar import, whereby the parties attempt to reach an amicable settlement of their dispute with the assistance of the third person, referred to as the mediator, who does not have the authority to impose a settlement upon the parties to the dispute. So this is basically the third person who will decide an amicable. There should be the amicable settlement. If one of the party is not agree, then go for the CIRP process. So the amicable settlement they are saying. And as we have already discussed that what is mentioned in the discussion paper, an operational creditor may undergo the mediation with the corporate debtor for resolving the dispute of commercial nature. So if there is any dispute, then how can they admit the application? I have no idea. In accordance with the provision of Mediation Act 2023, before filing application under section 9 and thereafter, they are also saying before filing application and thereafter, file the application under section 9 along with the report of the mediator. So before filing the application under section 9 and thereafter, file the application under section 9 along with the report of the mediator. So this is also thereafter. The word is thereafter is also having some confusion. If we want to file the section 9 application, and after filing the section 9 application, we can go for the mediation. I don't think we can go for the mediation, because it is saying that this is the pre-litigation mediation. So how can we approach after filing the section 9 application? How can we go for the mediation? So thereafter, this word is also having some confusion in my mind. So we'll discuss later. Now, the section subsection 2 provides that this act shall apply where the mediation is conducted in India. Basically, this was provided in the act. The mediation agreement provides that any dispute shall be resolved in accordance with the provision of this act. So the agreement, mediation agreement, is having some importance in itself. Now, what is the definition of mediation agreement? Section 3J of Mediation Act provide the definition of mediation agreement. Mediation agreement means a mediation agreement referred to in subsection 1 of section 4. So we have required to read this section also. So section 4 of the Mediation Act provides that mediation agreement shall be in writing. First of all, they have said that this should be in writing. So if we want to create any agreement for any company, we should incorporate a clause which is related to the Mediation Act 2023. So I don't think that there is any mediation, there is any agreement till the date after means before 2023. There we have mentioned any, we have referred any mediation act. We have given any reference of the Mediation Act because the Mediation Act is in itself came in 2023. So a mediation agreement shall be in writing by or between the parties and anyone claiming through them to submit to the mediation all or concerned dispute which have arisen or which may arise between the parties. And mediation agreement may be in the form of the mediation clause in a contract or in the form of a separate agreement. So they have said that the mediation agreement should be in writing and mediation agreement may be in the form of mediation clause. So we should insert a clause in the mediation agreement. Whenever we will draft any agreement, we should insert a clause related to the mediation because they have covered, because Mediation Act in itself covered so many clauses, so many commercial dispute related clauses. The mediation agreement is in writing if it is contained in or recorded as any document signed by the parties. So the mediation act agreement should be in writing, or if it is contained in or recorded as any document signed by the parties. So if we are not having any mediation agreement as of now, related because the Mediation Act come into force in 2023. So if it is contained in recorded as any document, they have also saying ki any document signed by the parties. An exchange of communication or letters, including through the electronic form as provided under the Information Technology Act. They have also admit the letter which is electronically if any exchange between the parties. So they admit these type of documents will be considered as for the mediation purpose. They can consider any pleading or suit or any other proceeding in which the existence of the mediation agreement is alleged by one party or not denied by the other. So they have included all this. A reference is in any agreement containing a mediation clause shall constitute a mediation agreement if the agreement is in writing with reference to in such as to make the mediation clause as a part of the agreement. So the if we have added any clause, if we have not added any clause, then the exchange communication letter should be there, or any document signed by the parties for doing the mediation, for executing as a mediation agreement should be there. So for going for the mediation, these type of documents required. Now, the parties may agree to submit to the mediation any dispute arising between them under an agreement, whether entered prior to arising of dispute or subsequent thereto. The mediation agreement in case of international mediation, if there is any international mediation issue involved, shall refer an agreement for the resolution in the matter of the commercial dispute referred to in section 3A. So the 3A we have discussed already. The 3A is there. This will be considered as the commercial dispute. What is the commercial dispute? Is the 3A. Basically, this was mentioned in the 3A. Now, the section 5. Section 5 is also very important of the Mediation Act, which what is provided by this section? The mediation, the voluntary pre-litigation mediation. This was provided as per section 5 of the Mediation Act, voluntary pre-litigation mediation, because the voluntary word has been used in itself in this section. So the mandatory, if the legislation, in the discussion paper, if they want to incorporate the word may, they want to incorporate the word shall, not may, then they have required to make the changes in section 5 section 5 of the Mediation Act also. Why? Because the voluntary pre-litigation mediation has been given. The subsection 1, because subsection 1 of section 5 is provide voluntary pre-litigation mediation. The parties can mutually agree to try pre-litigation mediation before filing any civil or commercial case, regardless of an existing mediation agreement or not. For commercial dispute of a certain specified value, because in discussion paper they have already discussed what they are saying. There are several recurring issues in section 9 application. What issues are there? The issues related to the disagreement on goods and services is there, because the regarding the quality performance of the goods and services provided. The contractual dispute having the allegation of non-compliance with the contractual terms or by either party, or discrepancies over the exact amount owed and alleged underpayment, and claim of the CDs against the OC for set-off or damages. So these type of 4 terms they have said that these common issue have been involved in generally in the section 9 application. And there are in total, they have already mentioned that total cases which was filed is 21,466 cases have been filed in section 9 application. However, only 3,818 cases was admitted. Only 18% cases was admitted. So basically, the section 5 in itself provided for the voluntary pre-litigation mediation. So if they want to change the word here, the may, they want to change the word shall, then they have required to make some changes in the Mediation Act in itself. Okay. Now, subsection 1, I have already explained. The pre-litigation mediation process must align with section 12A of the Commercial Code Act and associated rules. So there are the section 12A is provided in the Commercial Code Act, and the pre-litigation process should be as per this section only. Application be notified the tribunal. The subsection 2 of section 5 provides that this provision also applies to tribunals designated by the central or state government. It extends the opportunity for the pre-litigation mediation to dispute brought before the specific tribunal. So the section 5 of the Mediation Act provides that mediation panel. What will be the mediation panel? The subsection 3 provides that mediators qualified to conduct the pre-litigation mediation include those registered with the council. I have already discussed the mediator should require to be registered with the council. In fact, the mediation service providers centers also required to be registered with the council, and part of the court annexed mediation center and empaneled by the authority under the Legal Service Authorities Act and recognized by the mediation service provided under this act. Now, designation of mediation request. The subsection 4 of section 5 provides that parties may request a mediator through a high court appointed person or a designated authority under the Legal Service Authorities Act 1987, especially for the mediations under these clauses. And mediation panel maintenance subsection 5 provides the court annexed mediation center and authorities under the Legal Service Authorities Act are responsible for maintaining the list of mediators to support the pre-litigation mediation. So they will maintain the list of the mediators. Application in motor vehicle accident, the claim, if any claim, tribunal receives a motor vehicle accident compensation application and no settlement is reached as per this section, the tribunal must refer the parties to the Mediation Act. It was also provided as per the Mediation Act. So I think mediator is the next future of our professionals. The section 5, what is provided as per section 5, the next is there. The consideration of settlement by claims tribunal. If mediation results in a settlement agreement, it must be submitted to the claim tribunal for review and approval. And non-settlement report, if parties fail to reach the settlement, then the mediator prepare the non-settlement report. So what is provided in the discussion paper? We have required to file the report, file application under section 9 along with the report of the mediator. So the same was discussed as per section 5 subsection 8 of the Mediation Act, that if parties fail to reach the settlement, then mediator prepare the non-settlement report, or if they have succeed, they will the mediator will prepare the settlement report also for review and approval. So section 8 of the Mediation Act provides who is the mediator and how can be appointed as the mediator, because there are so many questions which is in our mind, who will become the mediator and how the mediator will be appointed. So this section provides nationality and qualification of the mediator. What is the nationality and qualifications for the mediator? Subsection 1 provides that mediator can be of any nationality. They have saying any nationality means in outside India can also become the mediator unless the parties agrees otherwise. However, the party should require to be agreed on this. However, foreign mediators must meet specific qualifications, experience, and accreditations standard. So, for the foreign mediators, they have mentioned they have required to comply some specific qualifications also if they want to practice in India as a mediator. And now, the freedom to choose the mediator and procedure. Subsection 2, which is provided that parties have the freedom to agree on the mediator's name and the procedure for their appointment, allowing the flexibility and mutual decision making. So this is basically provided as per section 8, who will be the mediator. An application for mediator appointment, subsection 3 of section 8 provides application if the parties cannot agree on the mediator or appointment procedure, the initiating party may apply to a mediation service provider for help in appointing a mediator. If they are not able to choose the mediator, then they will go for the mediation service provider. As we have discussed, who will become the service provider, they go for their help and they will choose the mediator. The role of the mediation services provided under subsection 4, the mediation service provider must appoint a mediator within 7 days. So this is specifically provided mediation service provider, if the parties has given the matter to the mediation service provider, then they have required to comply. They have required to appoint a mediator within 7 days. So this is specifically provided as per section 8. They will either appoint the mediator agreed by the parties. If there is no agreement or a selected mediator declines appoint a mediator from their panel. If they have the right to appoint the mediator, or if they will either appoint the mediator agreed upon the parties. If there is no agreement or the selected mediator decline, then they appoint the mediator from their panel also. The service provider can also appoint the mediator from their panel also. The mediator's acceptance. This is also important, that subsection 5 of section 8 provides that appointed mediator must confirm their willingness to serve within 7 days of receiving the appointment communication. So within 7 days was taken by the mediator services provider, and 7 days was given to the mediator for giving their willingness for appointment of the mediator. However, I think this time is very much, because only 2 days was given in our if we will see the in IBC, there is only 2 days given to the IP for giving their consent. So the 7 days should also be changed for 2 days, because this will also become as a the time consuming process if we will go for the mediation. Now, section 7 of the Mediation Act 2023 provides, what provides? The mediator shall not act as an arbitrator or as a representative or counsel of a party in any arbitral or judicial proceeding in respect of a dispute. As you all are aware, there are the Arbitration and Conciliation Act is also there. So this section is specifically restricted. Key mediator shall not act as an arbitrator. We cannot assume that mediator is the arbitrator. So this section specifically restrict the mediator for act as an arbitrator or as a representative or counsel of a party in any arbitral or judicial proceeding in respect of a dispute. That is the subject matter of the mediation proceeding. We presented by the parties as witness in any arbitral or the judicial proceeding. So mediator shall not be presented by the parties as a witness in any arbitral or judicial proceedings. So specifically, this section has restrict the role of the mediator. Mediator cannot become as an arbitrator. Mediator is not the arbitrator. Now, section 18 of the Mediation Act 2023 provides, what provides? That notwithstanding anything contained in any other law for the time being in force, the mediation under the Act shall be completed within the period of 120 days. This was provided in the Mediation Act. The 120 days limit was given as per section 18 of the Mediation Act, and the time can be extended for further period of 60 days. They have saying that they can extend the time for further period of 60 days. I don't think the 180 days is already provided as per our IBC code 2016, and the 90 days extension is there. I think 60 days is now extension is there, and total process required to be completed within 270 days. However, I have seen so many matters in which the proceeding is going on for 2 or 3 years, how they have still not completed. So the timeline is already given in this act, but I think this is the timeline which is mentioned in the Mediation Act is the very much the time should be reduced. This timeline should also be reduced if the mediation, if the pre-litigation process will come into force in IBC, the timeline should also be included, as per my opinion. The period of mediation mentioned, and this can further be exceeded by the 60 days. So 120 days and 60 days, now total 180 days is given also in the Mediation Act. What is the role of the mediation in the pre-IBC resolution? So what is the role of the mediation? So mediation is a preemptive measure to avoid the insolvency proceedings, because what is the brief? I have made a summary of the key benefits. Suppose if Mediation Act will come into force. Earlier, I was also attended a seminar and I have some confusion for the Mediation Act, that what will be the work, what will be the scope of work for the insolvency professionals if Mediation Act will come into force. But after attending this webinar, which I was attended earlier, some of the doubt has been cleared. And I have seen that the process of mediation is much before instituting the CIRP, means CIRP process, much before the instituting the Section 9 application process. So what is the key benefits of the mediation? Basically, I just make a brief. The early resolution, basically in the mediation, this is specifically provided for the early resolution. The mediation enable creditors and debtors to collaboratively address the payment issues, offering solutions like new repayment terms for the to prevent the insolvency. So the Mediation Act has been itself provide for the early resolution. There the online resolution is there, cost effective mechanism is there, because cost saving, we can save some cost which will be expended when we have go for the Section 9 application. So it is more affordable and faster than the formal insolvency, reducing the legal fees and the preserving the resources specifically for small and medium businesses. And the relationship preservation. This is also a process by which the relationship between the corporate debtors and its sellers, buyers, they can preserve the relationship. A non-adversarial process help them maintain the professional relationship, crucial for business reliant on long-term partnership. So there is some relationship will also be built up between the mediator also. So this is the relationship preservation mechanism. Flexible solutions. There is in mediation we have the some of the solution which was provided is the flexible solution, because they can modify the agreement. What is the terms of the agreement? They can change the agreement. So a flexible solution can be provided by the mediation, because mediation allow for creative tailored agreement like debt restructuring. We can go for the, if there is any issue involved for the debt's purpose, then we can go for the debt restructuring, which may not be possible in insolvency proceeding. If we will see, there are so many application which was filed because of the debenture holders are there, for the fees related issue. I have seen one of the I was appeared in this case, the legal fees issue is there involved, and Section 9 application has been filed by the senior advocate against the STC, State Trading Corporation. Is the, you all are aware, this is the government body. So I have attended so many hearings in this case. So this is basically the flexible solutions is there, because they can also amend their restructuring agreements. And confidentiality, unlike the public insolvency proceedings, the mediation is the private, protecting the business reputation and instilling the confidence among the stakeholders, because the confidence will be developed, because the management cannot be given to other person. And if the insolvency application has been admitted, then the management itself lose its confidence to others. So unlike the public insolvency proceeding, the mediation is the private, because this is the private process, because between the two parties, and third is the mediator, the whole proceeding will be involved. So mediation is the private process, and protecting the business of the and reputation of the parties. Higher compliance because in mediation, if we will go for the IBC process, there is a higher compliances. As the agreement are mutually made, parties are more likely to follow through, ensuring the voluntary compliances. So this is the lower compliances in the mediation. The court relief, it reduce the case loads, because we have seen they are that so many cases, as per the discussion paper, we have seen ki 21,000 and more than 21,000 cases has been filed, and only 3,800 cases was admitted, and all are settled. So this will make the reduce the burden on the NCLT also. Now, after their analyze, we should also analyze the section 12A and out of court settlement, because we have seen that the IBC code itself provide the section 12A. And the section 12A provides ki 90%, if the creditors, the 90% creditors are agree for the settlement, for withdrawing the application, then they can withdraw the application. So this is basically 12A is for the settlement, which is already provided in the IBC. So section 12A of the IBC code is the out of court settlement through the mediation offer pathway for resolving the insolvency issues without resorting to the formal proceedings, focusing on the quicker and more flexible solutions. Section 12A was introduced to allow the withdrawal, because we all are aware that 12 allowed for the withdrawal. So the same we are doing the pre-litigation. We are doing the pre-litigation in the mediation. We will settle the matter with each other. If matter will not settle, then we will go for the section 9 application. So this is automatically the purpose of section 12A has been resumed in if the mediation will came. So the process, the withdrawal is permitted only if the applicant, but however, there are some process in 12A, if we will go for the IBC, if we will discuss in IBC 12A, then at least 90% consent we have required. And sometimes I have seen some cases that double A means adjudicating authority not easily admit the withdrawal. They are saying you have to submit the proof of settlement, or they are asking some other proofs also. So they are not giving their consent for the withdrawal. So if we will go for the mediation, then there is the automatic settlement can be made between the parties by the third person is the mediator. So flexibility is there. This provision enables the distressed companies to settle the dispute and exit the insolvency process early, giving them a second chance to stabilize their finance, because they will settle their dispute in an initial stage, and this cannot harm the reputation of the company also. So what is the role of the mediation is out of the court settlement. So the pre-litigation mediation before filing the IBC application, this is the main role. We will settle the matter as per the pre-litigation. The mediation can facilitate debt restructuring, repayment arrangements, and that prevent the need for formal insolvency, because the formal insolvency is very tough. The mediation provides a platform for both the debtor and creditor to negotiate the solutions, such as the alternative repayment plan and reduce the obligations, and collaborative resolutions is there, because we have seen the section itself provides that both the parties should agree for the mediation. So the collaborative resolution is there. The mediation focuses on the collaboration, helping to preserve the business relationship and create outcome benefits for both the parties, because both the parties should take the benefits from the mediation if they settle the matter. Because if we will go for the IBC, we have seen section 53 is there, waterfall mechanism is there, and sometimes the operational creditor cannot get anything. Sometimes their settlement is will be made on a zero basis. So this is the collaborative resolution which will be provided by the mediation. This is specifically valuable for the businesses and rely on the long-term relationship with the suppliers and the clients. And tailored agreement, because mediation allowed for parties to craft the customized settlement, and they may include the restructuring terms, rescheduling payments, unique solutions beyond the IBC rigid framework. So the tailored agreement is the mediation allow the parties for this. So what is the key benefits of the mediation in facilitating the settlement under section 12A? Suppose what the key benefits? The cost effective, because the mediation is in itself is a cost effective process. So mediation is the less expensive than the court proceeding and can reduce the financial burden on debtors who are already struggling. Time efficient is also there. However, I am not agree with this term, the time efficient, because I think the provision of section 18, which we have discussed, that what is the time has been mentioned, 120 days. I think this time should required to be reduced in the mediation act itself, because only then this can become more effective. So the time efficient, the confidentiality, the mediation is a private process helping the companies protect their reputation and maintenance business confidence. So the confidentiality is there. This is very true, because if insolvency IBC process has been instituted, then no one want to give any further loan or want to give any finance to the company, because they have lost their confidentiality on the creditors. So this is the main, the confidentiality is there, because this will be decided, this is the private process, because mediation is a private process helping the companies protect their reputation and maintain the business confidence. Now the challenges and considerations. So what is the challenges are there? The creditors approval, because if we will go for the IBC, then there is a requirement to take the approval from the 90% COC approval has been required. So can be challenging as it demands nearly unanimous consent, because at that time we have required all mostly all the creditors consent, which may not always be feasible if creditor interests are differ. So sometimes they are not giving their consent. So this is the challenge if in IBC. So if we will go for the mediation, this challenge can be this challenge will be overcome. And lack of enforcement in informal agreement. The agreements reaches through the court to court of out of courts mediation rely on the voluntary compliance. So the enforcement, if the party defaults, the agreement may lack of enforcement without court involvement. So sometimes this is also a challenge for the mediation. This challenge for the IBC. This was the creditors approval was challenged in the IBC, but lack of enforcement and informal agreement, this challenge in the mediation. Because what is the problem is there? If suppose if we have settled the dispute, we are the parties of the dispute, but this is the private process, so no court involvement is there. So who will enforce the settlement? So this is the challenge in mediation. This is the challenge in IBC, and this is the challenge in mediation. And potential for delay. Creditors might use section 12(8) of delay formal proceedings rather than to genuinely resolve the dispute. This challenge in IBC, because sometimes the creditors use the section 12(A) only for delaying the process. So this is basically the impacting the debtors recovery prospects. So the debtors cannot recover and sometimes they have lost the business. So this is the main challenge in IBC. Now the mediation versus litigation. the litigation is the litigation in section 9 application and mediation. So we should discuss both. What is the mediation and how it is the litigation. The mediation and litigation differ because they differ significantly in the context of insolvency cases. Here are the key distinction. I have just provided some distinction between the litigation, which is provided in the IBC for section 9 application, and the mediation itself. The mediation is the informal because we have discussed this is between the parties, and the third party is the mediator only, and this is the private process. So this is informal. Basically, the mediation is informal, collaborative process where a natural mediator facilitates the negotiations between the debtors and creditors to reach the mutuality agreeable solutions. So it encourages open communication and seeks to resolve the dispute amicably. So basically, this is the informal, and litigation is formal. You all are aware there have required to first we have required to send the draft, the notice, demand notice. Then we have required to take the reply from the corporate debtor. If they have not submit their reply within 10 days, then we will go for filing for the section 9 application. So this is the formal process, and specific forms is also provided there. Some fees of NCLT is also required to be paid. So this is the basically formal process, and this is the informal process because online hearing will be online, all the process will be done online basis. So this is the informal. The adversarial process conducted in the court and tribunal where the judge and arbitrator makes the binding decision, because in litigation, if we will go for section 9 application through the litigation process, then the tribunal will be involved, judges will be involved. But in case of mediation, no judges will be involved, only the parties, and third is the mediator will be there. So outcome control. This is also the difference between the litigation and mediation. Outcome control. What we will achieve? The control in mediation, we know that the parties retain the control over the outcome. However, the judges or tribunal has the control over the outcome. As they collaboratively negotiate and agree on the terms, this flexibility allows them to craft the tailored solutions such as the modified payment plan and debt restructuring. So this is the control is between the parties. However, in litigation, the judges or tribunal shall control over the outcome, imposing a legally binding decision on both the parties. So the solutions are limited to what the court can order under the law, often leading to binary outcomes like the liquidation or formal restructuring. So this is the difference, and some other differences are also there. The cost and time efficiency, as we all are aware that I have already discussed above, that mediation generally faster and more cost effective because the online process will be initiated and between the parties and mediator only. So however, if we will go for the litigation, first of all, we have required to hire a legal firm for sending the demand notice, then for replying, and then for filing the application before the NCLT, then required to appear before the court in so many hearings. I have seen so many cases. There are more than 2 years. The court has not admitted the application under section 9. So this is the cost and timely efficiency process has been provided in the mediation. Litigation often costly due to the legal fees, the court fees, the time-consuming procedure. Insolvency litigations can take the month or even years, increasing the expenses for both the parties. So this is the main difficulty. And confidentiality. The mediation conducted privately, because we have discussed already that this is conducted between the parties and mediators. So this is very private process. But however, if we will file the section 9 application, then required to publish on the MCA portal itself. The company, if the company will go for the CIRP process, if admit the Section 9 process, then will require the master data on the corporate in the NCA portal itself show that company is under the CIRP process. So the confidentiality is there in if we will go for the mediation. So conducted privately, keeping the details of the disputes and settlement confidential. This helps to protect the debtor's reputation and maintain the business relationships. But in the litigation, a public process making the court record accessible to the public, which can damage the business reputation, because all the process with the court, so everybody can watch, because nowadays the court is already online. So the order will also come. We can make the Google search. We can see the order also there. So litigation is the public process. Make the court records accessible to the public, which can damage the business reputation and lead to the losses to the client and investors' confidence. So if we will go for the mediation, this problem cannot be faced by the corporate debtor. Now, the mediation and litigation is also differ in some other points I have also mentioned. That enforceability, the mediation settlement agreement breached in the mediation are typically voluntarily, and while they can be formalized and enforceable, they may require the additional legal support to be upheld in the case of the default. However, this is the weakness. Enforceability is the weakness in the mediation. However, in litigation, this is legally binding and enforceable. So this is main weakness of the Mediation Act. If we will settle the matter, how can be enforced? Because this is only decided between the two parties, and the third is the mediator. So who will enforce? The parties are not enforceable between each other. So this is the main lacuna in the Mediation Act. So, but however, in the litigation, the court judgments are legally binding and enforceable. Non-compliance with the court order can lead to the additional legal consequences for the defaulting party. Now, focus and approach. What is the focus? The mediation focus on the achieving a win-win outcome, because the mediator always want to try to settle the matter, with the mediator helping the parties understand each other's interest and negotiate a mutually acceptable solution. However, in litigation, emphasize the right and legal positions rather than the interest, because they will say the act has been provided this, the duty, the right is there available in the act. So the act in litigation, if we will go for the Section 9 application, we will consider the right and legal options available. However, if we will go for the mediation, the mediator will try to help the parties to understand each other's interest. Or however, in litigation, emphasize the right and legal position rather than the interest. We will not consider at that time the interest. We will consider what is the right and legal position of the parties. So it follow a winner top all approaches where the outcome may be beneficial to any party over the other. So this is the focused and focus approaches there. Now, what is the future of the mediation? As per the understanding, as per my understanding, the integration mediation into the IBC would help the streamline dispute resolution, offering faster and less adversarial solutions. Here are some reforms that could support this integrations. Mandatory pre-insolvency mediation. First of all, discussion paper. What is the discussion paper provides? The discussion paper provides may. The word is the may is there. The voluntary. This is the voluntary. Nobody can be bound by this. So this is may is the voluntary. However, in the if we will discuss in the mediation act is there. It's a very small act. I will also make some brief of this act. There is only 65 section in this act. I will show you to all the participants on here that there is only 65 sections are there and 13 schedules are there. The first schedule to 13 schedules are there. However, in IBC there are 11 schedules. This is the last, is the 10th schedules is there and is total. The 13 schedules are there. The 13 schedules are there. Last section is 65. So, however, in IBC, there are total we will see 11 schedules are there on 255 sections are there. So, a mediation act is a very small act. Now, what is the future of mediation? The mandatory pre-insolvency mediation. So, if they will introducing in the mediation a mandatory mediation, then this can be having a very wide future. Introducing a mandatory mediation process before filing for insolvency, particularly for operational creditor under Section 9, could help to resolve the dispute early and avoid the formal proceedings, because we have seen that this is avoided the formal proceedings. By the mediation, we can avoid the formal proceedings. So this preemptive measure would save the time and reduce the cost. So this is the future. Now, expanded use of Section 12A for the post-admission mediation, because Section 12A is itself provided in the IBC for the withdrawal. However, in mediation, this is before admitting the application, the solution was provided. The pre-litigation option is there. So if parties want to make any settlement between themselves, then can go for the pre-mediation. So Section 12A currently allow the cases. Withdrawal before admission, broadcasting its application to include the post-admission mediation would enable the dispute resolution at various stages of insolvency proceeding with creditors' consent. Cases should be resolved through the mediation without the completing the formal insolvency. So this is expand. Now the scope of Section 12A has been expanded by the pre-litigation, by the pre-mediation process. Now, creating of NCLT mediations panel. This is as per my opinion, ki we should, whatever the mediation panel should be created in NCLT. The establishing the dedicated mediation panel within the NCLT would facilitate the structured mediation services. These panels could include the specialist in finance and insolvency. This is as per my recommendation to the IBBI. If they want, they have said that anyone can become the mediator. So for the IBC, if they are talking about this clause, they are saying ki go for the pre-litigation, then they should choose ki who will become the mediator. They should also specifically mention ki what is the professional qualification should be existed with the mediators. So these panels should include the specialist in finance, insolvency, providing high quality mediation or complex cases. So this is also my suggestions to the IBBI. I will also submit, because they have invited the submissions of our suggestions on 24th November. So I will try to give my inputs to them also. And I also request to all the participants to provide their inputs, because if we will get together, we can make a bright future in mediation also. So establishing the dedicated mediation panel with the NCLT could facilitate the restructured mediation services. These panel could include the specialist in finance, insolvency, providing high quality mediation for complex cases. Now, the incentivization mediation, offering fee reductions, priority proceeding, or other benefits for the parties opting for mediation could make this path more attractive, because we can say that if you will go for the IBC to 9 application directly, then this will the fee you have required to be borne this fees. However, if you will go for the mediation, then this is the fee of the mediation. So we'll go more attractive path, and fee structure also should be there. These incentive would encourage the stakeholders to pursue for the collaborative solutions. So this is the future of the mediation. And binding enforceability of mediation agreement, because the agreement amending the IBC to make the mediated agreements binding and enforceable would enhance the confidence in the mediation outcomes, because we have seen the mediation process required to be made between the two parties, and third party is the mediator. So who will enforce the settlement? If suppose if the order for settlement has been passed, so how can we enforce the order if other party is not paying off to me as a creditor? So how can we enforce this order? So this is required ki amending the IBC to make the mediated agreement binding and enforceable. Only this can enhance the confidence in the mediation outcomes, ensuring that settlement are respected and reducing the likelihood of the further disputes. So this is the main thing. And training and certification of insolvency mediators, because I have seen the judges in NCLT who is passing so many orders. Sometimes they are not having, can't say, but sometimes I have felt only, because they are not having the proper knowledge of the sections also. So the proper training, this is mandatory required, the training and certification for insolvency mediators, creating a certification process for mediators with specialized skills in insolvency and financial restructuring could improve the mediation quality only. So this is required. These professionals would be well equipped to handle the financial complexities, enhancing the credibility of mediation solutions. And time limit, we have discussed that what is the time limit is provided as per Section 17 of the Mediation Act. I'm sorry, Section 18 of the Mediation Act. This is the time limit is 120 days, and further extension is also provided for 60 days. But as per my opinion and understanding, that the mediation, the mediation process is not too much time bound. The time limit should be reduced. The implementation or restrict 30 to 60 days only will be provided in the mediation period, because they have required to settle. Because if we are on the table, the both parties will come together, and the third is the mediator. So why we will give the 120 days or the further 60 days extension? We should restrict this process only 30 to 60 days. If they want to settle the dispute, they can settle the dispute within 30 to 60 days, not other than this. So the implementing the strict 30 to 60 days mediation period could ensure the resolution are reached promptly. So this time-bound approach would help them maintain the momentum of the IBC's formal process. Why IBC is not so much success in these days? Because the timeline was given is 180 days, further extension was given there. 270 days is the maximum time limit was given in the act. However, no matter has been settled within 270 days. They have taken 2 to 3 years. And I have seen in approving the resolution plan, the NCLT have taken 1 or 2 years in approving the resolution plan. So this is the main problem of IBC. The time limited mediation processes should be made, and this should be implemented strictly. This is the main requirement. If we want to create a future in mediation, then the time limit should be restrict 30 to 60 days mediation period. Now, the reduced the potential impact of mediation on India's insolvency landscape. What will be the impact of the mediation? If suppose if this discussion paper has been, the rule has this regulation has been passed or amended after some changes and come into force. So what will be the process? What will be the potential impact of mediation in India when it will come? So the reduce the case blockage and faster resolution. Suppose if mediation bill came after giving these strict timelines, after giving the proper training to the mediator, and the panel should be chosen among the IPs, financial CACS or the finance experts, if they have choose the right panel of mediator, or then the impact will come that reduce the case blockage and faster resolution. So the mediation can help the reduce the burden on the NCLTs, because we have seen in discussion paper itself provided that the 21,000 cases has been filed and only 3,818 cases were admitted. So this is will create the will reduce the burden on the NCLTs, enabling them to focus on cases that genuinely require the judicial interventions. Faster resolution would benefit all stakeholders, supporting the efficient operations of the IBC framework. But I am also saying that I have seen one lacuna in IBC in mediation. If we will, if the timeline will not be reduced, 180 days, that 120 days is there, and 60 more days are also provided in the Mediation Act. If this timeline is not reduced, I think some benefits can be taken by the corporate debtors, because they can also make the transfer, the third party transfer of their assets. They can also do these kind of process, because they think if we are not succeed in the settlement, then the creditor will go for the IBC process. So they can make some these type of arrangements also. So I think this the timeline is strictly the timeline should be reduced in the, if we will go for the mediation. So the potential impact of mediation is there, the cost saving to the for the stakeholders, because the the insolvency proceeding is the time consuming process, but mediation is not so and online process. So the legal counsel is also not required to be hired. So sometimes we can say this is a cost saving for the stakeholders. Now, preservation of the business relationship, this will be the impact of the mediation. If we will, if this will come into force, that this will preserve the business of business relationships. Okay, by the mediation's collaborative approach can help maintain the positive relationship between the creditor and debtor, because they only want to make the settlement between them, and there is no dispute related to the right and duties of the creditor and debtor. There is only they will try to make the positive relationship between the creditor and debtor, so the settlement can be processed. So this is the crucial for the business relying on the long-term partnership, enabling the continuity and goodwill even during the financial distress. So this is the main impact on the in our country if the mediation will come in IBC. And improve the compliances, because mediation outcomes are reached voluntarily. Parties are more likely to adhere to agreed upon terms, and this can reduce the enforcement issues, promoting a more responsible approach to debt and repayment. So this will improve the compliances and the great business stability. We can say, suppose if Section 9 application has been filed, the corporate, mostly cases, the company will go for the liquidation. However, in many cases, there is no successful resolution plan has been passed, so company will go for the liquidation. So this will become, if we will go for first for the mediation, then great business stability will be there, and the fear of the IBC can be reduced with the corporate debtor, because in this scenario there are so many investors, they want and the startups who want to start a new business. They don't want to incorporate a new company or LLP. They want to create a proprietorship firm. Either they want to incorporate a proprietorship firm or they want to incorporate a partnership firm. They don't want to incorporate a company or LLP because of this fear of IBC. However, if the mediation process will be introduced, then the greater business sustainability is there, and improve the compliances and preserve the business relationship between the debtors and creditors. So enhance the legal efficiency. Suppose if the mediation will introduce, then it will enhance the legal efficiency by diverting the cases from formal insolvency proceedings. Mediation allow the NCLTs to operate more efficiently. There are so many Section 7 petitions are pending, Section 10 petitions are there. However, some reports are there, some claims related applications are there, appeals are there. So they can do their function in more efficient manner, because the case burden will be reduced. So benefiting the entire legal ecosystem, faster cases processing at the tribunal level would lead to more prompt justice delivery. So this is basically the impact when, suppose if the mediation will come into force, so this will give this impact on the in our economy basically. So we have discussed now the Mediation Act also, as well as the IBC Act also. Discussion paper I have shown you. Now I want what changes suggested from the side of all the applicants. Please let me know is this regulation is proper regulation, or there is some changes have required to be made in these regulations. After discussing all the aspects of the mediation, please suggest all the participants now will please on your video, so we can discuss face-to-face issues of mediations, and as well as this section. What is the section the changes have required in these sections, which is provided in the discussion paper. So I have request to all the participants, please on their videos and make the suggestions which is required to be made. This proposal is there before you. All can see this. This regulations is there. The regulations is related to this, and I have discussed all the future of the mediation as well as its impact on our economy. I have discussed all this. Now please suggest, is the mediation is good or bad? If they have want to incorporate a mediation in IBC, so this will this is a good step of IBBI or a bad step? I think most seniors are there, so I have need their opinion. That the mediation is good for the IBC or not?
Madam, mediation is always a good in any case.
Yes, sir. But sir, I'm having the doubt itself regarding the mediation. And last week I was attended a seminar, and at that time I have cleared some of my doubts, because some of the professionals were saying that IP's future is in danger. If mediation will came, then IP's future in danger. So I don't think so, but I just want to know from others, and because seniors are there. So I just want to know from their opinion also. Mamta ma'am is there, and some of my seniors are there. So I just request to the Mamta ma'am to enlighten us.
IPs can take up mediation also.
Yes, sir.
IPs can take up mediation also.
Yes, yes. So this is my recommendation.
This is one of the opportunity. We should not take a threat.
Yes, yes. This is the opportunity basically. So the others, if anyone. Because in mediation they have said that mediator can become any person, but this is as per the recommendation of the council, and the council should choose only the person who is expert in IBC, means the insolvency professionals and the financial experts. They should choose only these type of panels of mediators. And what is changes in this section? Please suggest what should be the section, what should be the draft of this section. May is okay. I'm just asking with the other participants. They have said that new regulation should be inserted, and the regulation what should be inserted? An operational creditor may undergo the mediation. It means this is the voluntary process. So is this okay for the voluntary process, sir? Please tell your opinion, sir. Mamta ma'am, I'm requesting you to please suggest us on this. Is the mediation, is this the regulation is okay, or some changes is also required in this? So other participants, if
Madam,
have
in my
opinion,
opinion, there is nothing wrong in having a may there. I think it would be incorrect to compel anybody to go for a mediation.
Okay.
Where, for example, I have a strong case where I know that the CD is not intending to make the payment. Why should I waste my time in mediation? I should straight away go into the CIRP process. So I believe that may is a correct.
Sir,
Yes,
sir,
yes, ma'am.
One of my thinking is also there. If we will say this is voluntary process. So why the applicant will go for the mediation if already one other option is available, Section 9 application they can institute. So why they will go for the
So I believe
mediation?
that you see many times small corporate debtors are not aware of the implications of the CIRP process. And you see, mediation will help to guide them, to tell them of the threat to their company if their company is dragged into CIRP. And therefore, you see, in such cases, maybe mediation is a good option. But where you see there are people who are aware of these things, who are acting in a roughshod manner not to pay the operational creditors' dues, I don't think, you should force them to go for mediation. That will not be correct. You should give them the option so that wherever they want, they can go and enforce their rights.
Suppose, sir, if the 120 days was given in the Mediation Act and 60 days the extension was given in the Mediation Act, but the time has been reduced. If 30 to 60 days are reduced, and the may should be changed by the shall. May should be changed by the shall, then this is okay, or at that time?
Do I have a guarantee that mediation will yield a positive result? See, if I'm sure that mediation, if I as the creditor am sure that mediation is not going to have a positive result, with this CD. Why should I waste even 60 days? That is my point. That's my point. I may be wrong, you
Yes,
see, but
yes, sir.
that
Yes,
is
sir.
my viewpoint.
But as per my opinion, if we will say may words, if there is only may word is there, so nobody wants to go for the mediation. They always want to go for the Section 9 application.
I'm not really
They-
sure because my experience is different. I have found a lot of creditors who have sought to have their funds released via mediation from debtors. So my experience is different in this case.
Okay.
So I cannot comment on that.
Okay, no issue, sir. And this, the word is the dispute of commercial nature. Is this the correct word which is used by the legislature, or some amendments have been required in there?
This I really would need to, go through the definitions before I would like to reread the definitions before I
Yes,
comment
yes,
on
sir.
this.
Yes, sir. Yes, sir. Read it, sir. This is the definition. An operational creditor may undergo the mediation with the corporate debtor for resolving the dispute of commercial nature in accordance with the provision of the Mediation Act 2023 before filing application under Section 9 and thereafter file the application under Section 9 along with the report of the mediator. So this is the section. The regulation.
But madam, commercial nature, how is it defined? If
they have defined the commercial nature. I was already discussing the PPT. The commercial nature is itself, the definition is itself given in the Mediation Act. What is the commercial dispute? Basically, this is provided that Commercial Court Act, the definition will come from the Section 2, subsection 1 of the Commercial Court Act, and there are the 15 clauses they have covered for the commercial dispute related matters. These 22 clauses are there, which was covered under the commercial disputes. So this is specifically provided. However, as per my opinion, the commercial dispute word is not proper because section, I will just show you the section I have already shown you. Again showing Section 9, 5, subclause D of IBC itself provides. What provides? That AA can admit the application if no notice of dispute has been received by the operational creditor. So the application cannot be admitted if there is any dispute. So I think the word, the dispute, whether this is commercial nature or in any other nature, this word should.
I agree with you on this point. We cannot have this wording in this form, because if the wording is here, then it is automatically coming out of the Section 9 scope. So I agree with you on this point completely.
Yes, sir.
So
and
we cannot put the word disputes over here.
Yes, dispute should not be mentioned here.
Yes, absolutely.
So basically, and my recommendation is also there. Thereafter, they have also used a one word. However, I don't think I am right here or not. In accordance with the provision of the Mediation Act 2023, before filing application under Section 9 and thereafter. Suppose if Section 9 application have already filed, then they are again providing the opportunity to go for the mediation. The operational creditor
may undergo with the corporate debtor for resolving the
dispute of commercial nature
in accordance with the Mediation Act before filing an application and thereafter filing.
And thereafter.
Yeah, so I think there's nothing wrong with this. You see.
Actually, one more thing, ma'am, you have to see is along with the report of the mediator.
Yes, report we have required, and thereafter, then comma, they have used the comma, after thereafter, they have used the comma only.
That means it's a mandatory thing like that. Actually, along with the report of the mediator, it's mentioned.
So suppose if we have not go for the mediation, we have
Then-
only, we have directly go for the section 9 application.
Then,
So
madam,
how can, yes.
no, then, madam, my opinion is, you see, this is related to, and see, this particular clause is only related to mediation. Where you want to file a section 9 application, you are completely bypassing these things. You are straight away going under the IBC and filing a section 9. Where you undergo mediation, you first
Yes.
try mediation, and after that and thereafter, you file an application under section 9 if the mediation has not succeeded. So there, I don't think that there is a problem in this. But what I believe is that the disputes of commercial nature, I'm totally in agreement with you, that if we call it a dispute here, then where is the question of going to IBC? So I can agree with you on the dispute of commercial nature part, but I think thereafter over here is okay, because you see, this essentially means that first you go into mediation and then you go into section 9.
Yeah.
Whereas if you want to go directly into section 9, you are bypassing this act completely.
Okay, sir. So other participants give their views, if anything they want, what recommendation they want to give to the IBBI. I request to all my seniors to comment on this. So basically I was trying to cover all its aspect of the mediations, and who will be the mediator, and everything I have covered in my PPT. And I just want, if anybody want to say something, can ask any query related to the PPT.
I would like to give you a word of appreciation for, because you see, I admire the detailed reading with which you are proceeding with the PPT. You are going into the details of the sections by looking at each word and each, so I believe that you've done a really great job. So my appreciation to you.
Thank you so much, sir. Thank you so much, sir, for your all comments. So if anyone having any doubts, so we can discuss further. Otherwise, we'll stop the PPT. Anjali? Are you there, Anjali? So we'll take a break of 15 minutes, and we'll join after 15 minutes, sir.
Sure, ma'am.
Yes, yes. Thank you. Thank you. So Anjali, can we resume now? I'm inviting to all the participants, if they have any PPT related query or something, so we can discuss at the moment. Anjali, can you hear me?
Yes, ma'am.
Yes. If any participants have any query, they can discuss, or otherwise we can resolve now we can stop the workshop. So ask if they have any query, we can discuss.
Participants, please ask your queries or give your suggestions on the discussion paper on mediation. Ma'am, I think there are no points.
Okay, no points. Okay, got it. So, yes, sir. Yes, sir.
So we can conclude, I think.
Yeah, we can conclude.
Okay. Thank you very much, ma'am, for such a wonderful session on the topic mediation and IBC. Ma'am, please share your PPTs and also share your views on the discussion paper.
Yes, I will just share the PPT to all the participants.
Yes,
to the
please
MC,
share your
to
comments in
the
the email.
Anjali. Yeah. I just share, and thank you so much to the ICSI IPA once again for giving this opportunity to speak today. Thank you so much to all the participants who has listened very carefully. Thank you.